Ladies and gents, thank you all for being here this morning. We are getting started. Our first presenter is David Cleaver. David is one of our premier creditor defense lawyers. He also is one of the few who has actually been a creditor law practitioner for decades. I won't say how many, definitely for both of us. But he is a welcome resource, always a fantastic speaker, and we're lucky to have him. Please welcome David Cleaver.
You, everybody's in the room. Thank you, the audience at home. Yeah, anyone looked at my my bio? It's about 10 years and 10 pounds out of date. Yeah, going on 33 years in this business and in this particular section of the law. So whatever that's worth, there are people who stay in this for a long time. So today we're going to talk a little bit about the FCRA, the Fair Credit Reporting Act. I don't expect that many of you are actually involved in credit reporting. Maybe you are, but probably a number of our clients are. And we've been seeing in our office a big uptick in FCRA cases. The FDCPA cases are largely going down as regulatory and court guidance narrows us in on what it is we're supposed to do. And the vast majority of debt collectors want to do things the right way. And so as we're told to do things, how to do it the right way, we're doing it the right way. And so suits have gone down. FCRA cases have been going up. Seems to be an area not of bad compliance, but of consumer attorney baiting, creating claims, that kind of thing. This is an area where consumer attorneys and debt settlement companies and that kind of thing are largely trying to sort of create claims, I believe. And we're going to talk about the hoops they got to jump through to do that and how to sort of prevent that from happening. So first thing, basic disclaimer, not much to say here. You guys are all lawyers, you understand. I'm giving you information. I'm not giving you legal advice. I'm not your attorney. I'm not your client's attorney. Trust but verify. We'll talk a little bit about what we're not covering. So the FCRA is a large statute, covers a lot of different areas regarding credit reporting. And so we're going to go through the litany of things we're not going to talk about today. It could be in future seminars because many of these topics are an hour in and of themselves. So first, we're not going to talk about permissible purposes for obtaining credit reports, users of credit reports, and the ability and legal basis for obtaining someone's credit, reviewing someone's credit. That's a whole other area. It's a whole other area of potential liability. It's a whole other speech. We're not going to do that today. Reporting time periods, dates of obsolescence, date of first delinquency, all of those issues about when and what you can report. That's all under, you see the references to all the sections. Not talking about 1681C. We're not talking about fraud alerts, active duty alerts, all the rights of consumers to put things on their credit report, notifying potential other creditors of their situation. A big one we're not talking about is responsibilities and obligations of the credit bureaus themselves. There's a whole bunch of things that the credit bureaus have to do to comply with the law. We're going to sort of touch on that a little bit, but we're not talking about the credit bureau. All we're talking about today is furnisher liability, liability of creditors and debt collectors when they report debt to a credit report. Not talking about the consumer's right to obtain their credit report, use of credit report for employment purposes, investigative reports. We're not talking about creditors who use credit reports for making credit decisions, credit granting decisions, adverse decisions, notice requirements, all kinds of things in this law that we're not talking about. We're not talking about identity theft. All of the obligations under the Credit Reporting Act for identity theft. We're not going to talk about civil damages. Okay, I lied. We're going to talk a little bit about civil damages, but we're just going to touch on that in a little bit. We're not going to talk about the details of what those damages are and the amounts and all that kind of thing. And we're not going to talk about the use of credit reports for counterintelligence or counterterrorism. I don't know if you guys even knew that that was a thing. The government can pull your credit if they suspect you of terrorism or spying. And so there's all kinds of obligations of what and how they can do that. Didn't know if you knew that was in there. We're not going to talk about that. Credit reports, by the way, can be used for all kinds of purposes. People think about having good credit, having a good credit score being useful for obtaining credit, for applying for new loans, buying a car, getting a mortgage, that kind of thing. All true. But the FCRA allows folks to use it for employment purposes, to use it for insurance purposes. So Studies have shown, and the insurance industry has sort of lobbied and determined that someone's propensity to pay their debt correlates to their propensity to be a safe driver, be risk averse, things like that. And so credit affects in a lot of different ways. Anyway, we're not going to talk about all that, which probably lends the question, what are we doing here? We got to kill an hour. What the heck is left? We're going to talk about the obligations of furnishers, of data furnishers. Again, creditors, debt collectors, people who report information to the credit bureau to be then disclosed to the users of credit in various ways, whether these, again, employers, insurance companies, potential creditors, all that kind of thing. All contained under 15 USC 1681S. One section of the law, remarkable, we're going to be able to spend an hour doing that. But that's what we're talking about today. So let's start with a little bit of the background. So the FCRA, as we talked about, big law, and the whole purpose of this is expressed in the statute. I'm not going to read all this, but essentially, Congress said, we've determined that this credit reporting system that we have is vital to our banking system and our system of credit, that the information being on someone's credit report of their existing credit, their availability of credit, their past history of making payments, all that kind of thing is vital to our system. And the only way it works is if we have accurate information on the report, right? Makes sense. We got to be able to rely on the information on the credit report. So this whole law is based on how do we ensure that the information on the credit report is complete, accurate, truthful, all that kind of thing. I like section 4 where it says the credit reporting agencies exercise their grave responsibilities. I think that's a little extreme, but this is what we're talking about. This is, Congress said this is extremely important. And so, taking now to 1681 S2, S2A, this will be a little shorthand. We're going to refer to S2A and S2B. They're really two main sections we're going to talk about here under S2. So S2 is the underlying principle we're going to talk about, which is a person shall not furnish any information relating to a consumer, to any consumer reporting agency, if the person knows or has reasonable cause to believe that the information is inaccurate. Makes sense, kind of a fraud thing. If you know the information is not accurate, don't put it on the credit report. Okay, that's pretty simple. You may ask, what does it mean to know or reasonable cause to believe? And so thankfully here the statute gives us a definition. And it says that means having specific knowledge other than solely allegations by the consumer. Some other independent knowledge that would cause a reasonable person to have substantial doubts about the accuracy of the information. Great definition, keeps all of us lawyers employed, right? That's fairly meaningless. There's a lot of reasonableness, reason to believe, So these are little vague comments, but the idea being, it is not an absolute strict liability statute like the FDCPA and other things. It's not, if you report inaccurate information, you violate the law. It is only a violation of the law if you have specific knowledge other than the allegations of the consumer that would lead a reasonable person to have doubts about the information. Okay? So if you have reasonably, given the information you have, you believe it to be accurate, you're okay. Go on. A person shall not furnish information relating to a consumer to any consumer reporting agency if the person has been notified by the consumer that the specific information is inaccurate and the information is in fact inaccurate. Okay, step 2. So if you have reason to know that the information is inaccurate, don't report it. Clean it up. If you're told by the consumer that the information is inaccurate and the information is in fact inaccurate, you can't report it. Follow me so far? You know on your own, or the consumer tells you and you find out that it's inaccurate. So the consumer telling you alone is not enough to keep it off the credit report. If the consumer tells you and it's in fact inaccurate, we got problems. What does that mean? That work. Okay, so there's 2 ways that a consumer can notify you of this alleged inaccuracy. One is what I call a direct dispute, and what I'll call an indirect dispute. Logical. Direct disputes are disputes made directly to the furnisher, the creditor collection agency. Under S2A, A consumer who seeks to dispute the accuracy of information shall provide a dispute notice directly to the person at the address specified by the person for such notices. Okay, let me pause for a second. Statute does not require a creditor or collector to provide an address specifically for disputes. However, if you do provide an address specifically for disputes, if you notify the consumer in your website, on letters, on whatever, your communications with the consumer that you have an address for disputes, then the only disputes that count are disputes that are sent to the address specified by the person for such notices. My recommendation to creditors and collectors is publicize an address for disputes so that you don't get disputes in random places and become subject to them. The tactics we have found in some of our opponents, not going to name any names, is they have been sending disputes to random locations. We had a case where the consumer attorney found a fax number that was not publicized anywhere. They found it on a licensing application, we believe, where they had to put a fax number down. It's not a fax number that anybody uses. It's in like the CEO's office. They faxed a dispute letter to that fax number. Nobody saw it because they don't use this fax number, and they alleged we disputed it. You didn't do your obligation. So wouldn't have worked if they'd have given an address to send the notice to. But without that, any reasonable method of disputing it is going to be treated as a dispute. Okay? So just a little aside. Consumer who disputes sends notice to the address or to any reasonable location has to have a couple of things in it. It has to identify the specific information that's being disputed, explain the basis of the dispute, and include documentation necessary to substantiate the dispute. So, for example, I dispute the debt, thank you, signed Joe Consumer, is not a direct dispute under the FCRA, at least in my opinion. Doesn't qualify, right? Doesn't identify what information you're disputing, doesn't give you the basis for the dispute, or provide any backup. Now, a dispute that says, I don't owe $1,000 to ABC company because I paid them last January, here's a copy of my check. That's a direct dispute, right? They've identified what's wrong, balance, or the existence of the debt. They've given you the basis, I paid it, and provided some information justifying their dispute. Okay. If you get all of that information, then the consumer report, yes, then the furnisher has to conduct an investigation, review all the information, and within 30 days, complete their investigation and reply back to the consumer with their results. That's how a direct dispute works. I dispute the debt because I paid it. Here's my check. Got to look into it. Was that check actually received? Was it for this debt? Was it credited? Yada, yada, yada. Report back to the consumer. Yes, you're right. We've adjusted your credit report. No, it's wrong. Here's why. If the investigation finds that the information is inaccurate, notify all of the consumer reporting agencies you report to and fix it. Again, makes sense, right? This is how the system works. The consumer looks at their credit report, sees something that's not right, tells the furnisher why it's not right. The furnisher looks into it. If it's not right, they fix it. Makes perfect sense. There are a couple of exceptions to this obligation. First, the paragraph doesn't apply if the dispute is, at the reasonable determination of the furnisher, a frivolous or irrelevant dispute. That's great. Now we can get rid of all of them. We just determine this is frivolous, go away. And there's some definitions. Frivolous or irrelevant, we're talking about mostly failure of a consumer to provide information. This is the I dispute the debt, I don't owe it. That's a frivolous dispute. We don't have anything to investigate. We don't know what you're talking about. Or that it's substantially the same as a dispute previously submitted. I'm sure none of our creditor or collection agency clients ever get that. I dispute the debt because I paid it. No, you didn't. We looked into it. Here's why I paid it. Another week later, I don't owe this because I paid it. No, we already talked about that. Bring up something else. So frivolous or irrelevant, duplicate or or dispute with no backup, no details, no information. Those are frivolous, irrelevant disputes. They don't have to go through this process of investigation every time. However, on making that determination, you get 5 days to let the consumer know we're not investigating because it's frivolous, it's irrelevant, it's a duplicate. You didn't give us enough information. And to the extent you didn't give us enough information, you have to tell them that you didn't give us enough information and what information, if possible, we need. Okay. If they just say, I dispute, you have to say, we don't know what you're disputing. If you have any details, please let us know. If they say, I dispute because I paid it, we need a copy of the check. We need to let them know what the impediment to their dispute is. Finally, and this is a big one, no obligation to investigate if the dispute is submitted by, prepared on behalf of, or submitted on a form supplied to the consumer by a credit repair organization. Okay. These mass form disputes that come from credit repair organizations don't count. It has to come from the consumer. This one's great, except in today's world, very hard to tell. With AI generated documents, with social media documents, with CFPB documents, things just shared on the internet, very hard to tell whether a document actually comes from a credit repair organization or is this something the consumer copied somewhere and sent you that looks like it's coming from a credit repair organization. So I caution creditors and collection agencies from relying on this exception and ignoring their dispute obligations based on their belief that it comes from a credit repair organization. That said, I got one this week from a client, and it's on letterhead of a company that describes itself as a credit repair organization or a credit. Basically, it described themselves as a credit repair organization, and they said, we're notifying you as representative of so-and-so. Okay, well, that clearly is from a credit repair organization. They say it's from a credit repair organization. Some of the form letters say, I have consulted with a credit repair organization, whatever. So this may work in some circumstances. The big thing is 1681N and 1681O, the civil damages portion, the thing that we weren't going to talk about, doesn't apply. We just wasted 20 minutes of time. No, you can't, a furnisher cannot be sued civilly for violating this section. A direct dispute to the consumer, a direct dispute to the furnisher does not support a civil cause of action, even if the creditor entirely ignores it. It's a violation of the law, but not one that is enforced by the consumer who disputed the debt. Now, it is still subject to regulatory action, so I wouldn't ignore it. And some of the regulatory agencies do pursue these kind of things, particularly when it's endemic, when it happens all the time with particular creditors or collectors. Not so much with the CFPB. I think they now have like 2 people working, and one of them just making sure the coffee machine works. But you never know going forward. So I wouldn't ignore the direct disputes, but direct disputes do not have a private cause of action. So that's sort of screen one in my considerations of defending an FCRA suit. First thing is, was this a direct dispute or was this an indirect dispute that we're going to get to in a minute? Because if it was a direct dispute, if the consumer attorney is filing suit or making a claim alleging I sent you a dispute and you didn't investigate it, case over. You can't sue me for that. You can report me to whoever you want, but you can't sue me for that. That is a motion to dismiss right there. And forget about the FDCPA, which again, we're not talking about today. The FDCPA 1692E8 prohibits communicating or threatening to communicate credit information which is known or should be known to be false, including specifically the failure to communicate that a disputed debt is disputed. So all of these disputes that you get, whether they qualify as a direct dispute obligating FCRA investigation, are nonetheless disputes. And if you're credit reporting, you need to credit report the account as disputed. Notice that this section doesn't talk about disputed by the consumer, just that a disputed debt is disputed. So these credit repair organization disputes you get, we're disputing it on behalf of so-and-so, I believe still qualify as a dispute. So oral dispute written at any time a consumer expresses anything that says, I don't think I should have to pay this. It needs to be reported as a dispute. We've had cases where I think one of them was a medical debt, and the consumer said, my insurance should have covered that. That's a dispute. They don't have to say dispute. They don't have to say I disagree, anything like that. Any expression of I don't owe it, the balance is wrong, I shouldn't have to pay it, anything like that is a dispute. So in my opinion, when in doubt, market is disputed. Now, we have in recent years gotten a number of suits on the reverse side, which I still have a hard time with believing that it's legitimate, of what we're calling the undisputed cases, where consumers allege they have been harmed because they didn't actually dispute the debt and you marked it as disputed, and somehow that was harmful to them. I'm not sure how it's harmful to say that you dispute the debt when you don't. How is that that negatively impact the consumer? But we have had those, and we have had what I believe to be consumer attorney or credit repair organization setups where they intentionally sort of make the language vague in the letter so that either way they can argue you did the wrong thing. They use language that, are you disputing it or aren't you? Language, a form letter out there that says, I am, in order to determine whether to dispute it or not, I need your documents. Are you disputing it or aren't you? I think if you say, in order to determine whether I'm going to dispute it, it means you're not currently disputing it. Well, you're not saying you owe it. And so anyway, long story short, just because the FCRA may say you don't have to investigate because of these exceptions or whatever, nonetheless, if you know it's disputed, you have to mark it as disputed when you report it. So now, all of that has led us up to S2B. S2B, indirect dispute, is the only section of the FCRA that a furnisher can be sued for this dispute stuff. We're going to walk through all of the hoops and all of the obligations to make out an S2B case where consumers and consumer attorneys typically are unable to fulfill their obligations. So S2B says, after receiving notice pursuant to 1681 IA2, we're going to talk about what that is in a minute, with regard to the completeness and accuracy of any information provided by a person to a consumer reporting agency, the person shall. What they shall do is the same thing basically we talked about before. Conduct an investigation, which with respect to the disputed information, review all relevant information provided by the consumer, and report the results of the investigation. This is an indirect dispute because this is a dispute to the credit reporting agency, who in turn lets the furnisher know. So notice here, you have to review all the relevant information provided by the consumer reporting agency, and report the results of the investigation to the consumer reporting agency. Here, we're getting a dispute from the credit bureau, reporting our results back to the credit bureau. We're not communicating directly with the consumer. And if the investigation finds the information is incomplete or inaccurate, you got to fix it. Not only to the credit reporting agency that told you about the dispute, but to everybody you reported to. And if the information is found to be inaccurate, incomplete, or cannot be verified after investigation, then you have to either modify it, delete it, or block it. Okay? So if you get a dispute and you can't tell whether it's verified or not, you have to treat it as if it's not verified. So your options basically are report back to the credit bureau, we verified that what we told you is true, or we can't verify that it's true, verify that it's not true, and therefore we're fixing it, taking it off the report, et cetera, et cetera. So let's look at that obligation in parts, because these parts are significant. So it says, after receiving notice pursuant to section 1681 IA2. And that is where the consumer notifies the credit reporting agency of a dispute, either directly or through a reseller like Credit Karma. The agency, now Experian, Equifax, TransUnion, has 5 days to notify the furnisher. So let's think about how this works. The credit bureau, and again, we're not talking about the credit bureau's obligations. The credit bureau has an obligation to make sure that all the information on the report is accurate. And so part of that is there's a provision in the law that allows the consumer to dispute things with the credit bureau. Well, the credit bureau doesn't know whether this person actually owes this debt to this creditor. They just know the furnisher told them that. And so the way the law takes care of that is it says when the agency gets the dispute, they pass along that dispute to the furnisher. Okay. So-and-so said your information is inaccurate. Please investigate. Let us know your response. There's some screening that the credit bureau can do first, whether they actually pass it along. But if it passes their screen, it goes to the furnisher to then report back. Screen 1A. It says after receiving notice, go to 16. Person shall. There's a two-step process before we even get to whether this counts as a dispute. It has to be from the consumer to the credit bureau, and then the furnisher has to receive it from the credit bureau. Okay, that's significant. So only disputes to the credit bureau count, not disputes to the CFPB, to the Attorney General, to Credit Karma, to the FTC, to whoever. Only disputes to the credit bureau, directly or indirectly, count. So, first step that a consumer has to prove is that they disputed it with the credit bureau. And secondly, that the furnisher received that from the credit bureau. If the credit bureau dropped the ball and never sent it to the furnisher is not liable. We didn't do an investigation. We never knew about it. Even if the consumer sends a copy to you, receive it from the credit bureau. It'll be an indirect process. I'm going to cite to a number of 11th Circuit cases. There are cases for the FCRA all across the country, but we're in Georgia, it's a state bar thing, so I'm sticking with the 11th Circuit where we are. FCRA is all federal laws. We're going to have all federal decisions. So I've limited these sites to 11th Circuit. But again, similar cases all across the country. So Perk versus Ship says the FCRA requires furnishers to investigate the accuracy of information upon receiving notice of dispute. This provision, S2B, can be enforced through a private right of action, but only if the furnisher received notice of the consumer dispute from a consumer reporting agency. What the law says, the courts backed it up. If you didn't get it from the credit reporting agency, case over. Motion to dismiss, we didn't receive it, end of story. Screen 2, gotten through, they sent it to the Bureau sent it to me. After receiving notice pursuant to 1681 IA2, with regard to the completeness or accuracy of any information. To a non-lawyer, that seems pretty straightforward, right? But we're lawyers, we don't do that. Let's talk about what does that mean, accuracy and completeness. It only counts as an indirect dispute requiring you to comply with S2B if the dispute is to the accuracy and completeness of the information you provided. Let's talk about that. Hunt versus JP Morgan back in 2019, the court tried to wrestle with this idea of what is it to be accurate, accuracy and completeness, as opposed to what. And here they talked about a distinction between a factual dispute and a legal dispute. So plaintiff must show a factual inaccuracy rather than the existence of a disputed legal question. Here was about an obligation, whether the debt was still owed after a foreclosure action. So it was reported, and they argued that report is inaccurate because I didn't owe the debt because of this foreclosure action that somehow wiped out my obligation to make payments. And the court found this was an unresolved legal question, and therefore no obligation to investigate because it wasn't to the accuracy and completeness, it was the legal enforceability of the debt, and therefore no go. Kind of makes sense when you think about it. Underlying theory is if a investigation of this dispute is not going to yield a definitive result, why require you to investigate it? Right? No investigation could reveal the answer to this legal question without a court weighing in to give a decision. And so the 11th Circuit said, even if it turns out later that some decision comes down that the debt wasn't owed, some legal question, the fact that they reported it before that time, violation, because they had no reason to believe it was inaccurate at the time they reported it, which is again the standard we talked about, right? You have to have reason that would alert a reasonable person to the inaccuracy that you're reporting. that became a little bit difficult to deal with, this question of legal versus factual, because there was a lot of things that are in the middle. What is a bankruptcy discharge? The consumer says, I don't know the debt because it was discharged in bankruptcy. Is that a factual dispute or is that a legal dispute? It doesn't require any legal determination. It either was discharged or wasn't, but it is a legal question. And so we had a lot of litigation over what is a legal question, what is factual, where does certain things lie? And so very recently, this case is from 2024, and it's the main case in 11th Circuit that gets cited. And we actually just had a case in the 4th Circuit last year that expanded this to the 4th Circuit, and this is the new trend. This is the new way that we're trying to grapple with this idea. Holden versus Holiday Inn Club Vacations. There's actually several Holiday Inn Club Vacations cases out of Florida. I don't remember what the actual issue was, but there's a number of companion cases. And the court found that the problem for the plaintiffs in that case was that the alleged inaccurate information was not objectively and readily verifiable. That's the new buzzword. Okay? That's the new term, the new standard. Objectively and readily verifiable. Same theory goes, but instead of talking about legal dispute versus factual dispute, the question is this something that has an answer? Is this a dispute over which someone could determine yes or no? Like the bankruptcy discharge question. It's discharge in bankruptcy. Okay, that is objectively and readily verifiable. You can check the docket and see was a discharge granted when it was versus when the debt was. Is this debt discharged or isn't it? Okay. Now, I say that, and then there are some other cases that talk about bankruptcy discharges in the situation of, say, student loans, where maybe it was discharged, maybe it wasn't, depending on the status of the student loan. Those would not be objectively and readily verifiable, even though it's a bankruptcy discharge question, because the nature of the dispute is one that the furnisher doesn't know the answer and couldn't know the answer no matter what they did. And so that is now the new standard, objectively and readily verifiable. Okay, it still requires some lawyering to argue about whether this thing was objectively and readily verifiable. Our case in the 4th Circuit dealt with a damage claim, an apartment damage claim. And the defendant's argument was, I didn't owe that debt because the damage was not so much that it caused the amount that you're claiming. Okay, we're claiming that some piece of equipment had to be replaced, or the apartment had to be replaced. And they say, well, you charged me more than I should have been charged because the damage I caused didn't necessitate those repairs. Okay, that's not objectively and readily verifiable. Our client says it is, your client says it's not. No amount of investigation is going to yield a definitive answer to that question. And so we argued our client had no obligation to investigate because no investigation would be fruitful. And the court ultimately agreed, not objectively readily verifiable. So case dismissed. Doesn't matter whether you investigated or not. Investigation not necessary in Res 2B. So this is a big advantage to defendants in FCRA cases. Before we even get to whether you comply with the law or not, the question is, are you even obligated to comply with the law? And the answer is, if you can argue that the dispute, whatever it is you were disputing, is not objectively and readily verifiable, no obligation, motion to dismiss. Another case out of January 2025, as this thing develops, it says, the court said, we've explained that purely factual or transcription errors or a straightforward application of law to facts constitute objectively and readily verifiable information, citing Holt. Conversely, allegedly inaccurate information that stems from a dispute without a straightforward answer does not. This is another attempt of the 11th Circuit to define what does it mean to have a dispute as to the accuracy and completeness of information. So it's got to be a factual thing that is determinable. Again, I made a payment, here's my check. That's objectively and readily verifiable. That requires you to go back to the creditor and say, hey, did you get this check? Did you report it? I mean, did you credit it to the account? Is the balance after that check or what? But if they say, I don't know it because the charges were unfair, not objectively readily verifiable, no obligation to investigate, because you can't verify whether it was fair or not. Screen 3. So we talked about, was the dispute properly done in terms of logistics, sent to the right place, reported on to you, is it the right kind of dispute? Objectively and readily verifiable information. Screen 3, was the information you reported accurate? These are not necessarily in order. These are just 3 things. So we go back to S2A1B, which is overriding principle under Section S. A person shall not furnish information relating to a consumer if the person has been notified at the address for direct disputes or through the credit bureau, and the information is in fact inaccurate. That is a critical element to S2B case. If the information is inaccurate, if the information that the creditor reports is accurate, it doesn't matter what kind of investigation they did, because really, by definition, the investigation was reasonable because it resulted in accurate information. So a consumer can only pursue a claim under S2B if the information is inaccurate to start with and there was no reasonable investigation. So you have to have both. The consumer has to show, A, the information is not accurate and you should have known it was inaccurate by a reasonable investigation. So there's 2 ways to defend an FCRA case, same way. If the information is in fact accurate, case over. If the information is inaccurate, but we did a reasonable investigation and were unable, our reasonable investigation revealed it was accurate even though we were wrong, that's okay. Okay? Reporting inaccurate information is not in and of itself a basis for suit under the FCRA. Again, not a strict liability statute. Reporting inaccurate information is not a violation of the law. It is only reporting inaccurate information when you should have known better. So Feltz versus Wolfstar go back in 2018. Plaintiff cannot prevail on her claim against the furnisher in this case, pursuant to S2B, without identifying some fact in the record establishing that the information reported regarding her account was inaccurate or incomplete. You can't win, motion dismissed, unless you can point to something in there that is in fact inaccurate. Plaintiff's burden to show inaccurate information. Just because they disputed it and you didn't investigate it, that's not good enough. You got to show that what we reported was in fact inaccurate. So once we get through all of those screens, which hopefully leads us with a very small subset remaining, now we've viewed it to the credit bureau sent it to us. It's objectively and readily verifiable information, and it's inaccurate. Now we get to the question of reasonable investigation. Not the best place to be from a defense perspective, because now we get into a factual dispute. Now this is a summary judgment case, not a motion to dismiss case. We have to show that our investigation was reasonable. A little bit harder from a lawyering perspective. Hinkle versus Midland, main case in 11th Circuit on this topic. And again, this is where lawyering comes in, right? So when a furnisher ends its investigation by reporting that the information has been verified as accurate, where we're at, you investigated it, you said it was accurate, it's not accurate. Now we talk about whether that is a reasonable investigation. The question of whether the furnisher behaved reasonably will turn on whether the furnisher acquired sufficient evidence to support their conclusion. They concluded it was accurate when it was inaccurate. What did you base that on? And the court said what constitutes a reasonable investigation will vary depending on the circumstances of the case, and whether the investigation is being conducted by a furnisher, by a creditor, by a collection agency. Says whether the investigation is reasonable will depend on the status of the furnisher. Original creditor, collection agency, debt buyer, subsequent debt buyer. So again, not a great place to be from a defense perspective because these are all fact questions you establish, but it at least gives us that argument. So reasonable investigation is variable. So if we can say based on what we knew, what we had available to us, where we were in the process, the reasonableness of the investigation is not a static thing. Okay? As long as what you did was reasonable under the specific circumstances. Okay. Here's the big thing. Feltz versus Wells Fargo in 2018. Court said, regardless of the nature of the investigation a furnisher conducted, a plaintiff asserting a claim cannot prevail. Now, demonstrating that had the furnisher conducted a reasonable investigation, the result would have been different. Well, that's huge. So the plaintiff has the burden of proving that the investigation was unreasonable. How do they do that? They have to find and demonstrate to the court that there's something the creditor could have found that would have changed their opinion. Take the example of the check, right? It's another case we've dealt with. Paid the debt. Here's a copy of the check. What if the consumer says, I paid the debt, and they don't provide a copy of the check? And the furnisher goes back to the creditor and says, they said they paid it. And the creditor looks at their records and says, we don't have any record of a payment. Checked our records that we keep in the regular course of business. We got no check, no copy of a check. We never received a check. No payment. Furnisher goes back and reports it as verified. Nope. Now, subsequently, they file suit. They say, you didn't do a reasonable investigation. Here's a copy of the check. So, wait a second. You never gave us a copy of the check. We didn't have a copy of that check. We don't know where that check came from. And the consumer says, you could have gone to the bank and asked them to check on whether there was, you could have done X, Y, and Z, and that would have resulted in you finding this check, even though I didn't give it to you. Now we got a question. Was that reasonable for us to have to do that or not? But that's what the consumer has to do in order to maintain an SPV case. Not just your investigation is unreasonable, but here's what you would have found had you done what I believe to be a reasonable investigation that would have shown you were inaccurate. That's a big hurdle. Okay. So now, to defend these cases, go through all the other procedural things. It has to be something that is objectively and readily verifiable, and there has to be some evidence that there is an objectively and readily verifiable piece of information you could have uncovered that would have shown that the consumer was correct. Okay, now, even as a defense attorney, okay with that. If you got a dispute and there was information out there that you could have reasonably gotten that would have shown the consumer was correct and you didn't do it, and nonetheless reported back to the credit bureau that you verified it was accurate, okay, that's okay, now that's fair, right? But that's the extent you got to go through. That is rarely what a plaintiff is able to do. Typically, a plaintiff is going to say, I disputed it, you didn't investigate it, pay me. There's a whole lot more in this that you need to do. So Phelps goes on, absent that showing, a plaintiff's claim against a furnisher necessarily fails. Unable to show injury, yada, yada, yada. So motion to dismiss. You can't point to a piece of evidence that I could have found that would have shown this was inaccurate. You lose. Last thing before I take questions, because I think we got about 10 minutes left. And this is sort of separate and apart from all these other things we talked about, and that's damages. So when we talk about damages, we're looking at standing, right? Federal standing, you have to have an injury in order to proceed. You can't just file a claim because we violated the law. It has to be a concrete injury. And so this is another area where consumers typically are unable to prevail because the court has said it's insufficient for standing unless the plaintiff shows a concrete injury. And in this case, in Loesch versus NationStar, the issue was stress, anxiety, all the typical things that consumers say. Right? This was inaccurate in my credit report. I couldn't sleep. I couldn't eat. Dogs and cats living together. Everything horrible. Because I was just so stressed that my credit was messed up. And I spent, in this case, 400 hours trying to correct the inaccurate information. And in Loesch, the court said that that was sufficient damages. The fact that they had spent time and they had emotional stress was sufficient for a concrete injury. Not so good creditor. Go on to last year, Nelson versus Experian. This was a claim against the credit bureau, but the same principle applied. Here, the consumer relied on the same thing and said, I was stressed about my credit report. I spent all kinds of time trying to fix my credit report. Therefore, I've been damaged. Here, the 11th Circuit backed off a little bit. They said the time and money that Ms. Nelson spent trying to correct the error could not establish injury in fact unless those efforts responded to or attempted to fix an independent concrete harm. Okay. So the difference from Loesch was the information was inaccurate. I was being denied credit. Therefore, I had to spend all this time and energy to fix it. so that I could get my loan through. I was distressed, not because the credit report was wrong. I was distressed because I was being prevented from getting credit because my credit report was wrong. See the difference? So concrete harm, somebody saw my credit report, denied me credit, charged me more, something like that. That's my damage. And the damage doesn't have to be I paid more on the credit. Maybe I didn't get the credit card. Maybe I'm still in the process of negotiating with the creditor. I'm distressed because I'm unable to get credit, or the credit's costing me more. I'm spending time trying to correct things in order to cure the damage that was caused by somebody seeing my credit report. Oftentimes we find consumers say, I disputed it, you reported it as verified, you didn't do an adequate investigation, pay me my money. In deposition, we say, well, do you have any evidence that anybody ever saw your credit report? Well, no. No harm, no foul, go away. Okay? No concrete injury just because it's wrong. It has actual impact. Was your credit report, was your credit score lowered? And did anybody ever see that? Were you denied employment, charged more, denied insurance, anything? Or any impact? Did anybody ever see your credit report? If no, just the fact that it's inaccurate and we reported it as inaccurate and we applied to the credit bureau, so what? In essence, right? No harm, no case. Can't sue in federal court over statutory injury without having some actual concrete injury. This is something to bear in mind. Cases. Here, another case last year where the court said, here there was this threat of fictitious collection. And so this idea that I may be denied credit, right? My information on my credit report is inaccurate, and I'm concerned that my credit may be denied, that I may be charged more in credit. And the court said, no, possible future injury not sufficient for concrete injury. The fact that my credit report's wrong and therefore I might get charged more, not good enough. We had a case where a consumer, we asked him, did you apply for credit? You know, same thing, the standing. Did anybody see your credit report apply for credit? No, I didn't apply for credit because somebody told me, somebody they never identified, somebody told me that I wouldn't get the mortgage because my credit report was messed up. So I didn't bother applying because I knew that I wasn't going to get it. Well, no, that's not this idea that I've been injured because I decided not to apply because I didn't think I would get credit. That's not a concrete injury. Similarly, in this case, it was a medical account that was being reported. And depending on how much you know about credit reporting world, there was recently, a couple of years ago, a policy decision by the three major credit bureaus that they were not going to accept medical accounts under certain circumstances. One of those being any medical account that's less than $500. It's not going to appear on the credit report. Nothing legal, nothing regulatory, just a credit bureau decision that we're not wanting to put these things on people's credit reports. And so in this case, this was a $500, under $500 debt that the creditor, the collector reported to the agency. And the argued in this case, it was under $500, wasn't going to appear on your credit report anyway. So again, no harm. Nobody was ever going to see this account, so no standing. All right, so let's go through this, just summarize, and then take any questions from anybody. Do we have any people home? Can they ask questions? So when we look at direct disputes, again, remember this is only for regulatory action, which probably isn't going to come up. But A, are you a furnisher? Are you, in fact, someone that is reporting it to the credit bureau just because you're the creditor and didn't report it? So again, think about the creditor who collection agency reports it as a collection item. The collection agency is the furnisher, not the creditor. So the creditor has no responsibility for the reporting of the information. So are you a furnisher? Is it a proper dispute? Did it meet all the criteria of having specific information, the basis for the dispute, sent to the right address, sufficient detail, was it sent by a credit repair organization? Is the information accurate? We have an argument that it's not inaccurate, therefore no case. Did you conduct a reasonable and timely investigation? When it comes to indirect disputes, these are the things where we get sued for. Again, are you the furnisher? Was it sent to the credit reporting agency as opposed to somebody else And did the furnisher receive it from the credit reporting agency? Does it dispute accuracy or completeness as opposed to something that is not objectively and readily verifiable? Is the information accurate, which is an absolute defense of the case? And was there a reasonable and timely investigation? And then finally, the standing issue. Even if all that's wrong, even if they get through all the other hoops that, yes, you sent it to the credit reporting agency sent it to us, it was objectively and readily verifiable, we investigated it, and we didn't find the information that we should have found that shows it was inaccurate. It's in fact inaccurate. We're lying to the credit bureau. We should know better. If nobody saw it, you still can't sue us. You don't have any injury. Okay, sorry, we now realize that we fixed it before anybody saw it. No harm, no foul. So there's a lot of hoops that a plaintiff under the FCRA has to go through in order to maintain an S2B case. So I'm hoping now, when you see some of these, maybe they're not quite so intimidating, not so freaking people out that they're going to have to pay big damages. There's a long road between filing a claim under the FCRA and actually being able to make out a claim that is successful and result in some damages. I knew that was a lot. Questions? Any issues? I wasn't entirely clear.
That was surprisingly clear.
Sure.
What are you saying is the initial demands these days in terms of financial damages for a single plaintiff case? I know they're all over the board, but are you seeing kind of a ballpark figure as to right out the gate?
It depends. I don't know what Mike's picked up. Brian's question was what we're seeing in terms of initial demands for settling these kind of cases. And it really is all over the board. It's really, it's what I find is it's less about a case and more about the attorney that's pursuing it. It may come from the consumers themselves, but unlikely. There's a sector of the consumer bar that's looking to get in and get out, who's looking to make this as simple as possible for the creditor to settle and to get his money and move on. And so those are, we're seeing 5,000, 3,500, that kind of thing. And then there are the ones who really either want to litigate or who want to play chicken. They're, they come in, they say, well, I want $25,000, whatever, negotiate from there. So kind of depends on the strength of their case, and depends on really the appetite of the consumer attorney to want to litigate it versus want to settle and move on to that. I really answered your question, but yeah, kind of all over the board. Those are the two sectors. We usually have about somewhere between 3,000 and 5,000, and then 20,000 plus.
So how would you say the portions shake out between ones you're seeing that are attorneys versus cases that are just pro se? And are you getting many cases for your clients that are pro se driven?
In the FCRA world, not as many pro se, because again, it's a little bit more complicated. And those that are get weeded out pretty quickly because they don't go through these hoops. So most of the FCRA cases we're seeing are through attorneys. I don't know if there are any consumer attorneys in the room, but a lot of them do social media SEO type things where people, type in FCRA credit report or disputes, and their stuff pops up. If you have something on your credit report that's not right, call us and we'll represent you for free. And so most of these things end up going to attorneys because it's so easy to get a consumer attorney who will take your case on just for the attorney's fees, or for a contingency, and so people who feel aggrieved are typically going to attorneys. And our belief is a lot of these, again, start out with the attorney before they even get disputed, right? They go to the attorney, I'm trying to fix my credit, and the attorney says, well, here's what we're going to do. We're going to send this sort of vague dispute through eOscar, and we're going to see what the creditor does. And then we're going to undispute it, and then we're going to send something directly to them. We're going to keep sort of poking at them until we have an argument that they did something wrong. That's my belief as to how some of these things are happening. They find a technical deficiency, and then they try to exploit it, putting money to avoid litigation. But I'm hoping that some of the information today gives you some ammunition that you can push back and say, we think this case is a motion to dismiss. We're not going to pay you because we don't think you're going to get very far. All right, well, you got my information. Anything comes up, any questions like this, feel free to call me, email me, whatever, anytime.
Thank you. All right, we are back and we have a mutual thank you from Judge Bloom, myself, also Dick Marr, Shanika Collier, and Brian Kaplan, our co-executive committee for the bar section. Obviously, Adam Cleveland, our chair. And we are very lucky to have Judge Bloom with us today. She has been consistently one of our most asked for and then sought after her presentation speakers.
That's the table pretty
He'll deliver.
intensely for me with all the fine shine on right now.
Oh my gosh. So, as y'all probably are aware, she's the chief judge of Gwinnett Magistrate Courts, which means that she's covering about 100,000 plus cases a year. And if you are among our brethren, you have dealt with her for sure, or her decision-making in the garnishments cases, in which that county handles more than any other court in the state. I think that's 2 or 3 combined, if I'm being accurate. So we're very lucky to have her here today. And thank you. Judge Bloom, everyone.
Hey. I'm happy to be here. We were up having some preliminary discussions about what I like to refer to as high-level nerd stuff in the garnishment arena. But this presentation really isn't about garnishments. I could talk about garnishments for a long time. I like to say there's only a small group of people in the state of Georgia who actually really dive deep into the garnishment law. And those of us who appreciate the nuances of the garnishment statute, and I've been a judge now for 21 years in magistrate court and a lawyer for 32. So I didn't start out, I started out practicing constitutional law in the federal courts, and I represented cities and counties, which is how I ultimately came to Gwinnett, and I was the lawyer for the Gwinnett County Magistrate Court. And if you'd have told me back then that one of the things I would spend a lot of time on was debt collection, garnishment, levy execution, all of those things, I probably would have said, you're going to have to define garnishment for me. And now it's discussions we have daily in our court about the best way to process debt collection cases. So one of the things when Adam asked me to speak, he said, do kind of your thing again about ethics in debt collection. And my perspective is obviously going to be pretty different. It comes from a place of watching all these cases come into the court. I will tell you the interesting thing about debt collection from my side of the bench is that they are intriguingly often low-level judicial oversight cases. By what I mean is a garnishment case that no claim is filed or no traverse is filed is going to rock on pretty much without a hearing, without anything going. There are automatic processes built in. The same with like default judgments that come in. On a default case, somebody comes in and presents a default, and then they present the proposed order and those kinds of things. The volume is pretty heavy. So the things I'm going to talk about are what we see on our side of the bench that probably afflict some people. And I think we've all been guilty of them, including me. I'm a volume-based business too. So that's kind of the perspective I'm coming from today. Now, this quote I love from Potter Stewart, and I use it every once in a while when I talk about ethics, is knowing the difference between what you have a right to do and what is right to do. We say that a lot in magistrate court. I'll give you an example that's outside of this kind of arena. We have, like, years ago, the Supreme Court of the United States came out with a case that said the metabolism of alcohol is not an exigency. Therefore, search warrants for blood draws in DUI cases are required, which was a fun argument for a lawyer to make, that the metabolism of alcohol in your body creates an exigency for which a search warrant is not required. Nevertheless, the Supreme Court said you have to have a search warrant. So there are mechanisms now where law enforcement agencies can apply for search warrants for the blood draw after a DUI, mostly an accident. And our solicitor at the time, years ago, would talk about these and how these were kind of emerging. And we would say there's a difference between can you do something and should you do something. And there's a little bit of that in the law, as well as there is what you have a right to do and what you should do. This quote actually was from Justice Potter Stewart and came out of the big case that defined pornography. It was I Know It When I See It, which is the most cited case. And I think it was 1964, if my memory serves, but it's the most cited quote out of the United States Supreme Court, I think, of all time. So when we talk about ethics, it's the difference and the intersection of what the law allows us to do and how we do it under the law and whether we should. Turn in it. I don't know why it seems to be locked up. down arrow.
Is it frozen?
No, you didn't. It was Adam, for sure it was Adam. I can do it manually, I don't need to go there either. Now it's working, thank you, definitely Adam. All right, so the manners of debt collection, one of the things when I talk about debt collection is I talk about starting from a principle of avoiding debt collection using garnishment levy and post-judgment discovery. And in my court, most of the things I'm going to talk about obviously are in the magistrate court scenario. I think magistrate courts do a heavy volume of debt collection. A lot of, the high volume debt collection firms have volume-based business with us. So these are the primary manners of debt collection that we use in magistrate court. It's certainly transferable to the other state and superior court, but these are our big three. Now, I like to give some relevant magistrate court law because what I have noticed, and it's not just with lawyers, but it's also even with some of my more seasoned judges, people forget that when they do start to research something, everybody, because I think Westlaw defaults to case law. Case law is the absolute worst place to start. And one of the things that I think debt collection lawyers and lawyers in general ignore are the magistrate court rules. The magistrate court rules are a lot more informative than even some of our statutory, enabling pieces. So the magistrate court rules have a lot of great information about kinds of hearings you can have in magistrate court, how you proceed in magistrate court, what kinds of cases, can do video hearings even, or what kinds of cases can't. But I always say, look at the magistrate court rules first, then look at the code section. And the last thing you should ever research is the case law. So some relevant magistrate court law that I like to remind everybody about is that magistrate court is not subject to the Civil Practice Act. Any of our stuff, when I say our stuff, our legislation is going to be in 1510. 1510-2 is, I tell every new magistrate, I've been a mentor for a lot of new magistrates over the years. And I said, you should print out 1510-2 and keep it on your desk because that's all the stuff you can do. It's your jurisdictional Bible, if you will. So the magistrate court is not subject to the Civil Practice Act, but there's an interesting kind of fluff about it in the sense that sometimes we can use it. It says sometimes you can use it. And there are not everything procedurally is covered in the magistrate court rules or the magistrate court 1510. So sometimes we defer to the Civil Practice Act. 1510-50 is what governs post-judgment collection in magistrate court. And I would challenge any of you that said, oh my gosh, I was looking at that, perusing it yesterday, because I guarantee a lot of people ignore. Especially all of us who are seasoned in our practice areas, we fill in the blanks of the research over the years. Like we fill in we think what we think we know. It happens a lot for my judges in the elements of criminal cases and in preliminary hearings or things like that. You fill in the blanks without going back and refreshing sort of what the parameters are for debt collection, what the parameters are for post-judgment discovery, and just what a magistrate court case can do. Now, in the rules here, it says Rule 38, it talks about substantive motions. We get motions filed all the time. Most often, I just was in a review in a file the other day where the county filed a motion to dismiss. And the motion to dismiss, they asked to rule without a hearing. Well, Rule 38 says we have to kind of have a hearing on that because no party is required to even respond to a motion unless directed by the court. Rule 40 is also interesting in what I'm going to talk about first in debt collection is that pretrial discovery is not favored. It doesn't mean it's prohibited, but it has to be, it can only proceed if you have permission from the court. So if somebody serves requests for admission in a magistrate court case, I see that a lot in advance of trial, they're a nullity. If they don't respond, A, they're not required to respond and they're just null and void. However, and now probably, maybe I've reached 1 million cases I've reviewed in magistrate court in 21 years, but The issue that comes up is that I have seen it one time used where an individual was sued and they asked permission to do some pretrial discovery to determine the name of a corporation, if the corporation had any responsibility or liability in the case. So they were like, Judge, before we can go forward on this case, we want to know if this individual was acting as a corporate representative or acting as an individual. It was pretty lighthearted discovery is what I call it, meaning it wasn't intense, but that was something that was perfectly reasonable to achieve permission to do. So really why I'm telling you this is a lot of cases, if you're the one also getting the judgment, not collecting the judgment, setting it up in the front end to make sure you've got the right parties, because wrong parties is a great problem for debt collection, as you might imagine, where they roll through a magistrate court case. And I'll tell you, I'm pretty proud of our court processes. In our court, if you file a general civil case, we're usually giving you a trial within 60 days of the answer being filed. My timelines are pretty intense, and I like to be efficient with access to justice, as I like to say. So one of the things I encourage people to do is really set that judgment up for success in collection on the front end before you just think about collecting. How many times have I said, somebody hand me a piece of paper and say, this isn't going to be worth the piece of paper. I said, well, my signature's on it. And if you did a little more work on the front end, maybe. So think about those kinds of things. DBAs or how the party is identified could be solved with a little bit of work on the front end. Now, some more relevant law I always like to go over is that magistrate courts, we do have authority in the world of judgments in magistrate court, because judgments are, acquired by the non-original judgment creditor, meaning like a funding group buys all these judgments, which is perfectly acceptable under the law. It confuses the debtors a lot where they file a motion. I've never had a credit card with ABC Funding Source. When ABC Funding Source is the one that bought, the right to sue on the judgment, and they don't know. I do have standing orders in my court for two things because I feel like it solves a lot of problems. I want you to file that written assignment of the judgment, and I want you to file a copy of the original judgment in the debt collection cases. Some people use the FIFE and things like that, but I've seen a lot of motions to vacate judgments, which are permissible in magistrate court, and it just delays things. They want the vacation of the judgment because they say, I've never heard of the judgment creditor or the entity that's proceeding in collection. So 91160 is the grounds for relief from judgments in magistrate court. It defers to the Civil Practice Act very specifically, lack of personal or subject matter jurisdiction, fraud, accident, or mistake, and a non-amendable defect which appears on the face or record of the proceedings. Yet, despite what is in the law, the number one reason people want the judgment set aside is it was a default judgment and they said I wasn't served. That's not a basis. But it's those kinds of things with paperwork saying, no, the judgment was obtained. Here's a copy of the judgment attached to pleadings. I do see that. And I do think, honestly, that's a best practice when the person collecting on the judgment or the entity is not the original judgment creditor. Motions to set aside must be served as an original complaint. We get those a lot if they cannot be legally served as any other motion. I had an interesting case, and I see this every once in a while, where an individual had, he filed a motion in our court to set aside a judgment because he couldn't locate the previous law firm or the plaintiff to satisfy the judgment in the case. And the problem was that the law firm didn't exist anymore, and the plaintiff really didn't exist anymore. But the issue was that he couldn't close on his house or couldn't do a refinance without satisfying that judgment. So the problem we had there is I was like, all right, I got this. Now my first rodeo. I said, pay the judgment into court, and then I will give you a satisfaction of judgment. But it's those kinds of things. That judgment sat out there, and I had to check on my own whether it was still a viable judgment, whether it had died, a slow, painful 7-year death, whether it had been. I try not to use the writ names, especially when I'm speaking, because I just don't think I say them right. Even all these years later, very cautious or whatever you say. But that's just things to keep in mind. And I tell you these little anecdotes because I really like people to understand what happens before the judgment's entered and what happens after the judgment's entered. Because I really do think a full understanding of what you can do to set up a good judgment is going to impact the ability to collect it later, where it's not just throwing darts at a wall. Motions for new trial are also not authorized in magistrate court. People try to file those a lot, but those are not something we can pay attention to. So setting the table with some, I think, very important, relevant law in my world. I'm in a band. I love to play music. I play guitar and I sing in a band. I think every adult should make sure they have hobbies that are outside of the practice of law. My job is very intense. So I like to use music. 2 years ago, I used the Rolling Stones. I think if I was trapped on a desert island, I think it would be between the Stones catalog and the Beatles catalog for me to listen to forever. And when I went through the Beatles catalog, there are so many songs that match the practice of debt collection. I think you will be surprised. So hell, I'm going to use this from my perspective on my side of the bench. I'm going to tell you what I think are the biggest problems in ethics in debt collection that I see. Number one with a bullet. This song in 1965 went to the top of the US and the UK charts. Did anybody tell me what you think the biggest complaint I get about you guys is?
Can't reach them.
Can't reach them. Not communicating with the debtor. And again, I'm not just talking about after you have that judgment in your hand. I'm talking about beforehand as well. Not communicating with the debtor is a problem. I will tell you a little story about how it was a problem for me one time. And when this crosses into the ethical realm of, hey, we should have done better. A gentleman came in on a Friday afternoon and I was at work. It was probably like 4:30, 4:45, right? So they said, Judge Bloom, we have a guy out there. He's in tears. Can you come talk to him? Sure. So I walk out there and he had a garnishment case. And the safe deposit box at his bank was garnished. It was regular garnishment. And everything got satisfied. The garnishment was released. And after the garnishment was released, the notice wasn't sent to the bank timely. So the gentleman could not access his passport for his marriage in Jamaica, leaving the following day. So he couldn't get his passport out of his bank. I was like, looked up on the docket that everything seemed to be dismissed, but if the release wasn't really communicated to the garnishee, something fell awry. And I picked up the phone and tried to call this law firm. I randomly just started going extensions. I picked random extensions until I got a human being. And my frustration was growing. So I think in the baseline, and I'm not just talking about, I'm talking about anybody. If you call my court, you can talk to a person. I insist upon that. You push 1 to talk to my beautiful Ayana, and she's so smart. You talk 2 to talk to Shakira, 3 or whatever, to talk to Mary Elizabeth. But not communicating with the debtor. Are you hard to contact? Can someone actually speak to a live person? Do you have a system or process that supports requests to settle? Now, I do think accessibility, I take very seriously in my job because I call you guys my customers. I call my litigants my customers. I take very seriously that accessibility is an ethical responsibility. So one of the things that when I talk about debt collection is the efficiency on the front end that's not utilized as much as it could be. And this has to go with, this was a perfect song too. You say, I say goodbye, you say hello, hello, hello. That's the word. So I think in our court, we have some magical statutes that I think really help if used correctly. So I'm going to backtrack now. You don't have your judgment yet. A lot of times my litigants, my customers will file, I admit that I owe the debt and request a payment plan. And then what I do, and I'll tell you this because my situation in how I run my court is I never try to change your behavior because I'm not gonna. I adapt my processes to known behavior and how lawyers operate. So one of the things that happens is a lot of the lawyers will come in, right? And they'll say, Judge, we need 30 more days to resolve the case. Can we get a continuance? Can we get a continuance? Can we be on the calendar 30 more days? And you know what? I have so many cases that I'm not really interested in chasing your result, right? So I think if I meet my statutory obligation to you, which is I give you a timely hearing, and you want, and you're not ready, I say, all right, cool. You are not going to be a bad boyfriend to me or girlfriend. I am not chasing you. I'm going to take you out of pending, and you just call me and tell me when you want a hearing or file your paperwork. Because the way you, I don't want to say lie, but maybe fudge the truth in saying that we've worked it out and we have all the settlement paperwork and that's why we need the continuance. I see right through it. We know you don't. So then I said, all right, you got 30 days to either request a new hearing or submit the paperwork, but I'm not going to keep putting you back on a calendar. And I think actually I went outside and a lot of my debt collecting attorneys love that because they're not coming in begging to come off. And the other side of the coin is that payment plans, and this is what I'm going to talk about right now, can incentivize a judgment debtor to pay to avoid getting a judgment. Not having that on your credit, I see so many fair credit reporting cases in my court, and so many. If you can get a payment plan that they can work out as a consent agreement or a consent judgment, that not having a judgment on their credit report is a good incentive if sold correctly. So this magic statute does not exist for state or superior court to the best of my knowledge. If it does, nobody pays attention to it. When the judgment is to be rendered and the party against whom it is to be entered requests it, the judge shall inquire fully in the earnings and financial status of such party, have discretionary power to stay the entry of the judgment, stay execution, and order partial payments in such amounts over such periods and such terms as deemed just under the circumstances, and as well assure a definite and steady reduction of the judgment until it is fully and completely satisfied. Now, how it works in the real world is I've never sat down and said, tell me how much you make, tell me how much you do. Doesn't mean that you can't inquire a little bit about that or request it if you're struggling to come up with a viable payment plan. You have that remedy. Just tell the judge, say, hey, can we just inquire a little bit about their earnings so I can help decide what a good payment plan is going to be. I'm going to tell you right now, they're going to say, I'm not employed, it's zero, because it's the same problem I run into when I'm doing indigency screens for appointed counsel. But how it really works is, honestly, our creditors' attorneys do a great job of knowing what those payment plans could be or what their client is willing to tolerate. But a payment plan on the front end is a lot easier if they can agree to start paying something. Now, you'd have the right under the law to, let me show you this one. Okay, this exists in the law. And if you know about the statute, congratulations. I know about it, but it says the judge of the magistrate court shall not be obligated to collect such deferred partial payments on judgments. But if the plaintiff requests, he may do so at the expense of the plaintiff for clerical and accounting purposes. Yeah. Please don't ever, don't ever do that. I will lose my mind. The first person in my office is going to be our clerk of court. She's like, I don't know what to do this. I go, I don't either. I have to figure it out.
Makes you realize debt collection is so much fun.
We're gonna all choose, right? Pinky swear, we're gonna choose to ignore this one.
Now, it's now on my bucket list pre-retirement.
Yeah.
See me in court and be like, hey, and I'm like, no. So the difference here, and I just did dispossessories all day yesterday because I'm workshopping some new forms and I'm really hands-on, those of you that know me. So I was in there and I created these beautiful new forms and I thought to myself, let me try them out so I told my attorneys in the room and I said, this is what I'm going to do. And what was great is I was able to utilize these forms and I was like, I hate this. This doesn't make any sense. I mean, I always say court processes and forms are like plants. You need to water them, right? And give them a little sunlight. I think the reason we're successful in Gwinnett County is it's a constant state of reimagining our volume, how we process our cases, and we never sit still on that's the way we've always done it, which is a favorite phrase of any kind of court. I know you know, bureaucracy is great for innovation, right? It's great. So the difference between, and the reason I'm bringing up what I did yesterday is there are attorneys that all have different proclivities for how they want to resolve the case, right? Some prefer let's just go straight to a consent judgment. They agree. And the reason for the consent judgment is I'm going to aver that I will not utilize any debt collection processes like garnishment, levy, anything if you comply with the payment schedule. If not, I can submit an affidavit and begin collection processes. There's limitations, obviously, on appealing a consent judgment, but a consent agreement is really good too, in the sense that if sold correctly, the judgment creditor is agreeing to forego the filing of the judgment and a FIFE as long as the judgment debtor makes the agreed upon payments in a timely manner. Now, in theory, this incentivizes. If sold correctly, a lot of people, it's hard to get an apartment, your credit rating goes down, it's hard to get a loan. So if you say, all right, well, we'll do a consent agreement and they miss a payment, then you can turn it into the consent judgment. You're just layering some incentives because chasing it through garnishment isn't always super effective for employment and things like that. So I just say in the world of creditors law, focusing more on avoiding the judgment with payment plans, especially admit and repay cases, is a great collection strategy. So bottom line with this, if they can't call you, they can't work out a payment plan with you. So I don't think that's the best for your client, because the thing is that if they want to work out, they're telling the court, they're telling you in their pleadings, they want to work out a payment plan, but the only way that you can get them to do a payment plan is to come to court, which is fine, but work out that payment plan on that calendar. Don't make me kick the can down the road, or have some process that you can work out internally. Make them fill out a form to see what their income is. I don't care. What I don't see isn't bothering me, but you have an ethical responsibility to be accessible, not only to me, but also to the opposing party or attorney. And it's not just in the creditors' rights arena. The domestic lawyers are just as bad at this. They don't talk to each other either. Number two in my world of problems in this area of law is volume-based apathy. We've all seen the cases over the years where firms or people have been tagged with debt collection sanctions for how they oversee their cases. I mean, it's no mystery. Volume-based apathy is a problem when you're churning out, when you're carrying. It's not just in this area of law, it's also criminal lawyers. When we appoint them cases and they might be carrying 100 cases, it's tough. General lack of attention to detail starts coming out. Required forms are missing. It's inefficient for you and for me. We have cut and paste errors all the time. Like the judgment amount is wrong, or somebody utilized the wrong numbers from the last file they just had open. I see it all the time. It creates paperwork delays, or the delays are saying, I'm going to get in my settlement paperwork. I'm going to get it in. I'm going to get it in. So really, I think the number one question, and I'm saying this from a place of, I am just like you. I am a volume-based business. These were my numbers last year. I just care to show them to you because they were humongous. So last year, my general civil division, that's non-AMVs or any abandoned motor vehicles or anything like that, and not dispossessories, was 30,630 cases we processed in a year. And that was the filings. My garnishment division, magistrate garnishment, was 42,510 cases. And then we handle all the state court garnishments in a separate division by special designation order, and that was 6,183. So I also have the same problems with volume-based matters, and I am in a constant struggle. I audit files, I go through things just to make sure that our processes are not ignoring very specific requirements in the law, or we're not rubber stamping things we shouldn't because the pleadings weren't right, the problems weren't right, and then we loop right back into motions to set aside the judgment, all of that. It creates I call them sometimes when cases just go off the rails, I call them cyclone files because the paperwork just keeps adding up and adding up and adding up. So one thing I always like to remind everyone is that the most efficient way to get your judgment handled, to get your case resolved, is to draft the statement of claim with a level of detail that anticipates the default. You don't need to come to a hearing if it's a liquidated case, which most of these are credit card cases or, you know, even personal guarantee cases, loan cases, those kinds of things where it's paperwork. You know, I think some of the best practices is they attach the actual, you know, in what is it, microscopic font, albeit, but they attach the credit statements and the report to it. Obviously, if you attach anything that has a social security number specific to that individual, you have to play by a different set of rules to not file anything that discloses or makes anyone vulnerable to financial fraud, like stealing their social security number, date of birth, those kinds of things. Those have to be redacted. But I see a lot of it where the statement of claim is just filled out willy-nilly, and then it's a default situation, and then we have to have a hearing because the liquidated damages and the default was not laid out sufficiently in the pleadings. Poorly drafted or incomplete statements of claim are going to require a hearing 10 out of 10 times in magistrate court, whereas default judgments on properly drafted liquidated damages claims will not. So Rule 43.1 is the rule. Default judgments and civil actions. The party seeking the entry of a default judgment shall certify to the court the following. See, again, another Beatles song that goes right with it, right? It's crazy. The date and type of service, you know, the military affidavit, the date on which proof of service was filed. That's a big one. Certificates of service, proof of service is where people get a little sloppy sometimes. So those are the things I don't need to read to you because I gave them to you in the materials. But I encourage everyone to draft it out the front end like you were going to get a default. So the best practice, I think, in any initial filing, anticipating the need for collection. Because if you're going to get a judgment in your favor, which in most of these cases you are, you should draft everything and do everything up to the point the judge signs it to set your client up in the best way to collect on it. So have the allegations verified, then you don't need a hearing. Is it verified? Make specific allegations about the debt owed. How you format your statement of claim. Did you list it all out? Principal, interest, all of those kinds of things. If the plaintiff is an assignee of the debt, make sure to attach a copy of any written assignment. I'm telling you, that avoids the, I don't have a credit card with ABC funding. Do the math. Make sure it's the right math for the right case, and know what the interest and costs that the law allow you to decide. If I had $1 for every time somebody included state or superior court costs in one of our pleadings, I would be on a tropical beach right now drinking something out of a coconut. So it's those kinds of errors, and it is a volume-based business. I am too. So one of those things is what kind of oversight. See, again, I don't care too much for money if money can't buy me love. Maybe that one doesn't apply. But oversight protocols are non-negotiable. They are non-negotiable for me and my court, and they are non-negotiable for any volume-based business. Now, here's the quick getting to the ethics. Can you initiate collection efforts on a corporate debtor that has been administratively dissolved or is defunct? Absolutely, you can. The law is clear that 14.2, 1421 allows you to collect on a dissolved or defunct corporation. And here's the reasons: to collect assets, to discharge any liabilities, or do any necessary act to wind up and liquidate business and affairs. So yes, it doesn't matter that it is defunct. It still may possess assets. It might be in receivership. It might have just been a little mom and pop operation, but you can still initiate collection. However, there is literally no excuse for not doing a quick search on the Georgia Secretary of State Corporation's website. See it all the time. That will tell you, I see all the time people initiate debt collection not knowing the viability of the company that they are collecting against. What's the business status? What's the principal office address? What's the registration date, registration status, the agent's name, physical address, or any filing history? Darts at a board is not the best way to collect on judgment. So the issue that I know is always a big issue in this world, is it ethical? See, come and get it, another Beatles song, perfect. Is it ethical to blanketly engage in debt collection processes against a defunct or administratively dissolved corporation? If you look at that sentence, there's one word in there that should jump out at you, and that's blanketly. I think you should have a good faith basis to believe that the target of the collection effort possesses property of the debtor. The law in garnishment land, and this is what we're going to talk about first, because garnishment is the garnishee is the subject of a lot of this. It is the garnishee just rocking along, doing nothing but just minding its own business, and it gets. I venture the banks get hundreds of garnishments a month, right? So if you have no good faith basis to believe that Wells Fargo has assets of the judgment debtor, is it ethical to collect against them when you have opportunities to collect, opportunities for discovery for post-judgment? So this case came out a few weeks ago. And I will tell you, as someone who, when I started this, I said, I am a garnishment nerd. There's not a lot of us out there. But this case was brutal in its cutting right through the red tape on how these are going to be framed. Chief Justice Peterson wrote in his concurring opinion, they could not reach the constitutional issue. And let me tell you, the Supreme Court, I'm not interpreting what they said. They said they are not dying, that's probably hyperbole, but they are very interested in being able to test the constitutionality of the garnishment default statute on the violation of the excessive fines clause. So here's what it said, and I'm going to read it. It's worth reading because it sums it all up. A frivolous lawsuit is filed against a judgment-proof defendant who doesn't bother to respond. The defendant's failure to respond results in a default judgment for tens or hundreds of millions of dollars. That judgment, of course, is not worth even the paper it's written on as to the assetless defendant against whom it was rendered. But the plaintiff can then send out hundreds or even thousands of garnishments to large companies with lots of assets and no connection to the defendant in hopes that one of them makes a simple mistake and drops the ball on responding. The plaintiff has now manufactured an 8 or 9 figure windfall from deep pockets of a company whose only fault was a failure to return paperwork timely. That's about as direct a concurring opinion can be. Now, the Supreme Court and the Attorney General have now expressly identified ethical concerns regarding the use of default garnishment statute to turn worthless judgments into collectible ones. And I didn't see the agenda until today, so I see you're kind of talking about this. I'm not stealing too much thunder, but so I'll kind of go over it a little bit. But this was a big case that we were all looking at in my court, because what's interesting about cases that come out in magistrate court, it's petition for review, right? That sends it to state court. Well, in our world, the state court garnishment cases are the ones that really have the chutzpah to go to the Court of Appeals, because we're talking about judgments that are more than $15,000, right? So we're talking about big dollar judgments that will go. The last couple of times the Supreme Court has had these, they've had procedural or statutory bases to resolve the appeal. So they haven't been able to directly resolve any constitutional challenge to the statute. So this was what was in the NBC Universal Media case. The language said the Attorney General acknowledged, and the Attorney General filed a brief in the case, that the Attorney General acknowledged that using the garnishment default judgment statute to, quote, entrap unwary third parties, end quote, rather than to simply locate a judgment debtor's funds would raise a host of ethical as well as constitutional questions. They also said in that case, the garnishment default statute is on questionable constitutional footing, at least as to the excessive fines clause of the Georgia Constitution. I don't know about you, but I read that pretty clearly as to there is an ethical responsibility in debt collection to go back to what I started with, using the tools that the legislature has given us to try to, number one, avoid the need for judgment collection through accessibility and being able to fashion, if a willing judgment debtor is willing to pay on a payment plan, to try to do it before the judgment's even issued, or avoid the need for garnishment levy and all those other. And by the way, I could talk for hours about levy. If you really have a hard time sleeping, call me. I will talk to you about levy. But in the world here, and what we're talking about also, once you have a judgment, there are tools in the universe of law that give you the opportunity to conduct post-judgment discovery. So one of the things that traversing a garnishee's answer, I will put this in here, I just tell you, because we've seen it a few times, is not a strategy. I've seen it once or twice where the plaintiff bears the burden of proving with more than just argument that the defendant is indebted to the garnishee and the amount the garnishee would have paid into court. I have seen it where and I don't want to get off to talking about garnishments because again, that's another thing that could last for days discussing. But what happens in the traverse is the plaintiff traverses the garnishee's zero answer, crossing the fingers that the garnishee doesn't do anything or show up at the hearing, which sometimes they don't. But then you have to show how much money the plaintiff still bears the burden, can't just rely on. Think about it this way, under the Civil Practice Act, there's no default on a substantive motion. The plaintiff still must establish that the garnishee had assets of the debtor at the time they filed the answer, and it's only up to that. So I tell you that because the bottom line, and you can read this on your own, is that the court finds plaintiffs, if they find the plaintiff's traverse was unfounded, attorney's fees against the plaintiff shall be awarded. And I've seen that as well too. But really what I'm gonna end with is you can't, under garnishment law, I do not think manufacturing a good faith basis is viable. By that, I have heard over the years, well, I just garnished all banks within 25 miles of the debtor. And my point is that all banks are within 25 miles of the debtor. Also, most people online bank. So you have tools in your tool chest. And one of the things are you say, yes, Judge Bloom, but some of those tools suck. I'm going to tell you, you can ask for more. The relatively lame questions that 1510-50D provide for magistrate court post-judgment discovery, if you want to be in magistrate court, we do allow 91169 authorizes a judgment creditor to take a deposition or propound additional interrogatories. You just have to ask and say, hey, we need a little more information. It would be, I can't imagine a judge saying, hey, we want to be a little bit better and more targeted about how we collect this judgment. Can we ask a few more questions? There's a difference between that and asking 800,000 questions, because I know the questions, the statutory questions are lame, but we've had people say, can I take this person's deposition? Because what I told you about the corporate code, we just want to see if there's any assets of the corporation that are remaining, or if there's a receiver, if there's something going on, can we do it? Yes, because 1510-50 says you can. So here's what this Lattimore, I know I'm stealing the wind out of it. Hey, I pay attention, I'm a nerd. Here's what I say is why it's important to sum up is that in Lattimore, the Georgia Supreme Court, this was a case that came out in 2024. They acknowledged that there was no evidence in the record to indicate that the plaintiff engaged in any post-judgment discovery or that she tried to collect the judgment directly from the judgment debtor. So the Supreme Court and the Court of Appeals are paying attention to efforts at debt collection and whether the efforts are made in good faith as an effort to collect the judgment from the correct party. So the last thing I say, and I always end with this, please, 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 timely file your satisfaction of judgment. In that happy, joyful day, you get the judgment satisfied. I don't like it when I see cases come in or people cry to me or they file motions saying I have to close on a home. I mean, it really holds people up. I told you about the the safety deposit box guy who needed his passport and the release wasn't timely enough So the bank wouldn't let him access his safety deposit box to get his passport to go get married in Jamaica. So timely filing the satisfaction of the judgment, and that goes back to the oversight of volume-based processes as well. What's the mechanism? Who's doing it for you to make sure that the satisfaction is filed in the correct place on the correct docket, and that you are meeting your ethical obligations to wrap up a debt collection case appropriately. So my last thing is, if you from the bench, is be familiar with the law. Know both the court rules and the statutes. I cannot stress this enough. It's just not for me, but state court, superior court, federal court in particular, the local rules first, state or superior court rules or the federal court rules. Or I used to practice in the middle, northern and southern district, and all of their rules were very different. So you have to look at those first if you're trying to figure out what to do. Then go to the code, then go to case law. I will say in the garnishment arena, case law is not super helpful because the code was completely overhauled in 2017, right? So when I look at garnishment law, I have to really figure out whether that piece of the law existed pre-Strickland, right? So you have to match up the old garnishment code with those cases versus what the new, and they're all new numbers and things like that. So case law is not always the best place to start. Be thorough and detailed in your pleadings. I'm going to be better and faster if you are more thorough on the front end. Communicate with the debtor on a payment plan if appropriate. By the way, we talk about all of you behind your back, so I know who's not doing these things. You are not hiding. We're like, oh, them. Promise. Have at least a good faith basis to initiate targeted collection and get your paperwork in timely. And just be nice. That's it. That's the secret. My son is a junior. Adam used a very old bio. My daughter graduated from Georgia Tech. She is an industrial engineer, lives in Dallas, very smart young woman. Even in the bio, it says she time qualified for the Boston Marathon. By the way, she placed 349th out of 11,000 women in the Boston Marathon. so I wish that would have been in there. But my son he's a junior at the University of Georgia, and he's in the marching band. And I always told him, we had this conversation the other day. I said, babe, when he was little, I'd say there's just 3. And I asked him, I said, you remember? And he goes, yes. Just 3 things you need to be. And this works as a kid, as an adult, in the practice of law. Be smart, be kind, be brave. That's it. That's it. That's the secret to life. And the last, Beatles, you never give me your money. You only give me your funny paper. And in the middle of negotiations, you break down, right? Did the songs of the Beatles, I hope, maybe will resonate a little bit as to what I'm talking about and how I've presented this. Because my mantra always is, be better on the front end. Once you get the judgment, utilize the tools that the law gives you to collect that judgment. Accept the fact that some judgments aren't collectible. And don't try to take sow's ears and turn them into silk purses, because the Georgia Supreme Court is real close. They want a case right now. I think it's pretty obvious. So maybe they've encouraged even the legislature to take a look at it in that case. And you're going to talk about that next. So I'll stick around for a few questions if you have any. I appreciate everything you all do. I will say that as a general rule, the creditors' attorneys that practice in our court are kind and decent and do a great job navigating people who have significant judgments against them and things like that. I often have said they give you a better deal than I might have on working it out. So I appreciate all that you do. It is an intense area of law because of all we have to navigate to deal with. And I am also encouraged and valued that you think talking about ethics and debt collection is a worthwhile endeavor. So with that, thank you.
And yeah, so what we've got is exactly as Judge Bloom described. There has been, since about I mean, it was probably our last go with the law was 2020, maybe a little bit before that, we had some.
17 was the biggest,
Yeah,
right?
no, well, 16 was the one, the 18, one was the biggest change.
Yeah.
Since the Strickland decision, 2016 just reinstated the law basically, and then 18 got interesting.
Oh, 17 was Strickland.
17, 16 was Strickland, like 15 was Strickland happened, 16 we put the new bill and the rewrite into effect, and then we made the biggest changes in 17, 18, but it is after 16 is when they started having those, essentially, sorry, this is my fault.
Sorry, I sidetracked.
But no, it's 2016, we had a new garnishment law written from whole cloth because in 2015 they declared our state's garnishment law unconstitutional. And so we had, subsequent to that, a couple of amendment bills that most of our membership are aware of in 2018 and 2020 that passed. But during that time, a cottage industry of a very small or one firm arose that was filing multiple garnishments, not the way that many of us do, where 3 or 4 local banks, which thankfully a lot of them are kind of indulgent about, no one gets to fit over, but dozens or 50 or 100 garnishees per garnishment, and seeking that double default that we thought was impossible because when in drafting law, everyone involved assumed that if you got served with a thing, didn't answer it, and then got served with a copy of a judgment, personally, that had your name on it, and then had a quarter of a year to respond to it with a simple motion to get out of it, it would never happen that somebody would get stuck. And yet it happened again and then again. And now it is starting to happen frequently enough that some of our members and their creditor clients are experiencing this directly. And so Brian is here to kind of help us navigate that situation that Judge Bloom brought up, where you've got garnishees who were essentially just a target for a displacement of someone's obligation into any viable pocketbook. So Brian, do you want to pick it up from there?
Sure. In a prior life, I used to file thousands of garnishments, but after the statute was deemed unconstitutional, I stopped filing in that manner almost entirely. I feel like instead of having a shotgun approach, you do need to have more of a silver bullet now, if you want to be taken seriously. But I thought that Chief Justice Nels Peterson's concurring opinion at NBC Universal was particularly interesting, and I circulated to everybody that's an officer for our section upon receiving, because we looked at some of the briefing before it was argued as to constitutionality, but they literally, the question was, did the trial court err by rejecting the garnishees as applied to facial constitutional challenges to Georgia's continuing garnishment default statute, OCGA 18-4-43, subpart A. And they dubbed the issue, just as you mentioned previously.
Well, I don't use the word dubbed the issue. Very clear.
They did it on procedural grounds.
They were able to, they had to, I think that's the default, to resolve it on a procedural basis.
Yeah, and I think that was probably the proper outcome, but I read very closely and then talked to a colleague that wants to be able to potentially be on the defense side of trying to have the statute deemed unconstitutional or get some court-made law as to how it should be interpreted going forward. And I think that Chief Justice Peterson's right in part. But it's going to be very, very fact intensive. And I think you need to do your post-judgment discovery before you haul off and file hundreds of garnishments, or even if it's just 5 and they're all for, I don't know, $5 million or you need to have done some.
They're looking at that, obviously.
Yeah. I think I'll say on behalf of the section, as my guidance, I think most of us need to remember what we were actually doing, which is trying to collect funds from those who owed them, which means that I think a lot of us don't get into these scrapes because we are still practicing this way. A lot of our clients are financial institutions, and so when we see somebody who's a financial institution, which is what is happening in most of these multi-garnishee cases, because you'd be filing a different affidavit in a continuing garnishment, and if you're saying that they work for all these different companies, you'd probably be called out for that lie quickly. You just have to remember there's no moral or ethical basis to insist that entity pay what they owe only because of a slip up. Now, granted, it is in defiance of the court's summons, but we all may have clients there at some times. We are now starting to experience that we are in fact having clients who are in that situation. And so, it is in need of a legislative change. We have not been able to get a sponsor for a garnishment bill the last 5 years. If by coincidence
So exciting.
yes. It's sad that some of our more needed technical bills don't really get the excitement at the Capitol that one might wish. If by chance any member of the section were elected to office, it might be a thing that could be amended, but the point is that it has not happened yet. So we shall see if that becomes an issue for the future. Meanwhile, it seems like there is a problem that needs a resolution, and it sounds like
That it's a huge problem. It's just something in bigger cases. I do not see rampant abuse of the garnishment processes. I just don't. I said, one of the issues though that needs to be addressed, I think, and I wrote an order. I was telling you, I wrote an order. It's a closed case now, but I wrote an order about how I had a case where a garnishee paid off the judgment. Like they got a default judgment on, and I can't recall if it was a traverse or because it's a while back, but they paid the whole thing off. And then the defendant files a claim and says, well, the judgment's been satisfied. And I'm like, a judgment's been satisfied. But there's nothing in the law that talks about, like, if you want to talk about joint and several liability or in, whether there's an indemnification somehow, that only happens if it would be in the order or in the law. And neither of those had happened. So and the choice was either it's a windfall to the plaintiff or a windfall to the defendant. And I don't know that everybody's like, it'd be a windfall to the plaintiff. I'm like, but it'd be a windfall to the defendant as well. So that's a hole in the law that needs to be resolved, is how those judgments interact.
And it's funny because we have that situation arise sometimes, and some of y'all may have experienced this too, where, for instance, a closing attorney has missed a judgment out there, and so now that closing, and this is kind of the same thing, a third party is now on the hook for a balance that they didn't earn themselves through some action. And so I've had a third party have to pay me off, like a closing attorney, for instance, and I've had a garnishee have to do it as well, and say, I'm sorry, I haven't paid this thing off. And so we essentially got my client to agree to sell them the judgment against the defendant, which still exists because it's two separate things.
Totally fine.
And that way, at least the pass-through is one balance still in circulation, not a double windfall for a plaintiff, because even my clients are not prepared to go there, thankfully. So it was able to be resolved in what we thought was an ethical and fair way, even for the third party.
My situation too, I was dying for it to be appealed. It was a state court garnishment case, but the defendant, I ruled in favor of the plaintiff, and the defendant, for lack of a more eloquent way to put it, botched the appeal because it's not a direct appeal because it's a garnishment. So it's a what? Certificate of immediate review. And I think what happened, just kind of reading between the lines, not, we haven't done this a minute. The Court of Appeals wrote like a 2-page order dismissing the appeal, but I think they read my order and they were fine with it. So they just didn't take it. If that makes sense. Sometimes they kind of go, it's fine. But I did not, when it came back down, I was like, I can't fix this for you. So that case kind of died on the vine without any resolution. But I worked really hard on that order to try to get some clarity on, because it's a strict construction, garnishments are strict construction statute too. So we have to look first at the interpretation of the law and then second at any case law interpreting it.
I would also point out that there is a tension between the Civil Practice Act, the Garnishment Code, and what
100%.
a creditor is trying to accomplish, because time is, you could say time is money. That could be a Beatles song. I don't know. I'm more of a Rolling Stone fan, but
I did that 2 years ago.
but sometimes an attorney may not be in a position to do the discovery if assets are being pilfered or
Sure.
dispersed very quickly, and so there's that tension there. And I don't know that the garnishment is necessarily the right way to go about doing it. It may be that you ask for some other court order about a specific asset if you know about it.
Well, I've appointed, there's receiverships and there's injunctive relief to dissipate assets, all kinds of superior court type remedies.
Sure. But it gets very, very difficult, from time to time to get clients to think in those terms as opposed to, well, I can get a quick hit with the garnishment, much cheaper. So.
And I should point out, y'all, that we were lucky to have Brian here on the subject too, because he actually was defense counsel on the more recent of these cases that went off on appeal and succeeded in getting that garnishment judgment unwound against that financial institution. So
They're a registered investment advisor. I have to correct you on that.
Oh, that's the one where it's, yes. I know.
Great call. No, it was actually very elegant because they did point out, and this is something you should be aware of. You know, the garnishment statute identifies that the use of the
Wrong
form is automatic invalidity of the garnishment in total. So when you're looking for that 9/11/60 facial error that is not amendable, if you choose a garnishee that is not actually a financial institution and use the financial institution garnishment form, they can now use, thanks to that case, unequivocally that failure on your part to use the correct form as a basis to escape the garnishment. Now, say for years, folks have asked me what to do when you don't know what type of institution you are going after. The simple answer is, if it matters enough to get it right, you just use the regular form and the financial institution form. One of those two things is true for everybody.
Correct.
Yeah, that's true. That was a clever argument. It's a good argument.
Smart guy.
Yeah, it's a good argument. And I had not seen it before where they just essentially nullified the garnishment because they said the wrong form was. I wasn't aware of that in the law before, correct? Right?
And the poetry of it, because they didn't have that form insistence pre-2016, that was part of the new code. And the beauty of it is, being in derogation of common law, the plaintiff is sitting there going, well, it says here that they shall owe it. We are using the strict construction of the statute. And then Brian walks in and says, yeah, that same strict construction says you use the wrong form. It's all dead anyway. Yeah, we'll be strict construction. This is great. Yeah. So these are resolvable for now, but it would be nice to have some clarity on both the issue of how you transfer a judgment from a third party that gets paid off for the defendants or not, and to have some different mechanism for creditor institutions or garnishees that get into a, God help them, double default and don't find their way out.
Well, and sometimes the garnishees just don't do anything. I mean, they have an obligation to
Don't get me started.
file. I mean, sometimes they don't file an answer. You send them a notice, they ignore it. I don't have,
Work for that.
those issues are real too, because you can only lead the horse to water so many times. If they don't utilize any of their own remedies through their own, apathetic processes, then that is a problem.
We had one over here and then David.
Yeah, on that point, the court order, I just read through it briefly. It talks about the constitutionality and saying it's excessive fine, but nothing in it talks about 18-224, which says it's a $50 fine. What's unconstitutional about a $50 fine if you seek to modify the default?
They're gonna determine whether the judgment is a penalty.
Right.
There's a problem in the law about is it a sanction? Is it a penalty? What is that judgment? Does that make sense?
The original theory is just replacing the money that they might have had and didn't
Yeah.
give you and hid by not answering, but it's becoming increasingly obvious on the evidence of these cases that is not what is happening. Yes, David.
Yeah, so that's my question. It's kind of a narrow question, but you brought up the idea of the plaintiff having to provide evidence of what the amount should have been.
Yeah, that's in the law.
Yeah, I know. Well, just speaking from my own experience, we don't know. So we got a bank account. We know there's a bank account because they provided a canceled check at the time of opening the loan. We know there was a bank account at that bank. So if I file a garnishment on the bank of an account that I knew existed, bank doesn't answer, we get a default. I send discovery to the bank, send me your records. They don't respond. Now it comes up for a hearing. I don't know how much is in the bank. I have no idea.
We've had people request additional time. It doesn't come up as often, David, but it does in the sense that, hey, they're not, I'll be like, let's get them personally served. And sometimes, we do. We've had in continuing garnishments, they've showed a canceled paycheck and we can calculate the money and all of that. We've said, hey, somebody brought a witness once and said they had a bank account here. They told me that. I don't know that if it's uncontested evidence, then it's the preponderance standard. But here's the tricky part of it is that I don't know it's when, and I've had to talk to my folks about it too. it's still just the amount they would have had when that answer was filed.
Correct.
So you're
Well, now
still
we don't know.
guessing, you don't know. And then there might be some opportunity for discovery there. I don't know that I would turn my nose up at it because it's probably the best. If you asked for it, it'd probably be the best. And then there's sanctions for discovery and all of
Because
that.
that's what I always do on the phone. They say
Here we
we
go.
go at the bank, give me your records
Yeah.
for the
We
last
we are at
year.
our limit. I'm clearly not our time for more information, but yeah,
Nerds.
David,
Can I just ask one question, to Judge?
I love
our next
that.
presenter was like.
I know, but because she brought this up, I just am interested in the concept of burden shifting. What David's question really kind of goes to is, at what point in time does the burden shift to the garnishee to be able to, if they're not going to produce discovery, when do we just say, they haven't produced discovery, the burden, we've met our burden, the burden should shift to them?
Shift the burden. The statute still requires the plaintiff. So there's no burden shifting. Now, in the real world, if they're not paying any attention, I don't want to say out loud scant evidence, but we've had it. We're like, look, I have had hearings where in like continuing, they do work there. Here's some proof they worked there. Here's what I think they were making. We've looked up before what someone in that salary capacity average makes, divided it up. So there's creative ways to arrive at a quasi-speculative number. You know what I mean? But there's no shift to the burden.
Thank you so much. If you're planning to stick around, we will mob you after the presentation. Otherwise, we will try to get in touch later on. Will and David, you want to come down?
Sure.
All right, for our next presentation, we are going to have David Dolinsky and Will Downs do a segment on commercial lease enforcement. I have found over the years that there's actually quite a bit of overlap with our creditors' rights and commercial collection practices and commercial lease enforcement. A lot of us, including myself, do a little bit of both. So we thought it would be a good opportunity to have some speakers cover some of those issues. I've known both David and Will for probably more than 20 years, have litigated cases with and against both of them. They're both outstanding attorneys. Will Downs is the founding partner of Downs Law. They focus on real estate litigation and primarily represent property owners. David Dolinsky is a sole practitioner. He's been practicing in the field of commercial litigation, including real estate disputes, collection matters, general commercial cases, and he's been doing that for, I think, over 25 years now. So again, I've known David and Will a long time. They're both fantastic attorneys. They're both good friends, and I know they'll have some great information for you all today about commercial lease enforcement. With that, turn it over, gentlemen.
All right. It's good to be here. So yeah, I'm Will. So we were gonna kind of split this up. We don't have any sort of huge formal plan, but I'm gonna kind of focus on the landlord's perspective, and David will talk about the tenant side. I'm gonna go first, and it may be my only opportunity to speak because of Professor Dolinsky, actually philosophic. So we'll try to get all I can in before he starts. And yeah, it's pretty casual. If y'all have any questions, feel free to jump in and interrupt. And if we run out of time, we'll tell more stories. Like I said, I kind of primarily do on the landlord side. And kind of one of the first things that, if a client calls me, kind of one of the first things I look for is like, kind of do a little bit of due diligence. A lot of times it'll be, it can run from like this tenant's like just now not paid rent to they haven't paid rent in 2 years and the balance is like $200,000. So, in any case, I'm always trying to get a few basic things first. Give me the lease, and a lot of times it's hard to imagine, but some landlords don't understand that giving me the lease means also giving me any amendments that have been added onto the lease, or giving me any assignments to the lease. So it's often tracking down, like, do we even have all of the necessary documents? Give me the amount they owe. It's often surprising to me that a lot of clients don't actually have a formal ledger, keeping it on the back of a napkin, so to speak. Like, have you sent any other prior notices to the tenant? All of those things are helpful to me to determining like what is going on in the situation. So once you kind of get the key documents, kind of look and see, what is it that we have going on here? With a lot of commercial leases, as you may know, if you practice in that area, just a show of hands, just real quick in the room, like how many people have done like a landlord tenant case? So it's often, it can be difficult to even figure out like who is the landlord and who's the tenant, right? I mean, like a lot of times your client may not be the named party on the lease. They may have acquired the shopping center or office from someone else or industrial building, whatever it is. So they may not be the named tenant. So if you're just going off the lease and you send a demand letter that landlord X is asking for money, that might not be the right entity. So clarifying with your client, like, hey, who is the owner of the entity now? I don't necessarily need the deed, but can you verify like who owns the property? Likewise with the tenant, like you may get a tenant that's in the name of a business that doesn't exist. You look them up on Georgia Secretary of State, and they don't. That's not actually a registered entity. So in that case, it's important. It's important to do a little due diligence to know who even you're dealing with on both sides of the situation. And then the premises, like it may kind of goes without saying, but I'm always surprised that when I get like a 50-page lease and I can't even tell like what the address. A lot of times it may be, when they've done the original lease, the shopping center hasn't been entirely, constructed yet. So premises may be identified by a site plan in reference to some sort of, lot number. And that doesn't help. So if you're going to file an eviction on someone, the sheriff has to go somewhere to execute the writ, right? And they're not, if they go out to the address and it's not a right address, or if it says, lot 400, but that's not what's on the door of the facility, you're not going to be able to get that tenant out. So kind of just even figuring out like where you even are located is important. Google does help a lot with that now. I remember first started to do this, we didn't have the benefit of that. So you couldn't just go to the street images and see what's on the door. You had to rely on the managers or agents to tell you, what's physically located on what number. And it's often surprising how, few times that what the lease says is actually what's on the door. Things get changed over the years. And one thought to pay attention. It's an easy fix if you catch it in time. You just put the right number. Important to know that. And then figuring out what the amount that they owe is. Right? I mean, you can't just rely on your client's ledger because they'll often, put things in there that they may calculate things in a manner that a court wouldn't have. Right? So, this comes up a lot, mostly with late charges, where the client may, the way they're doing their accounting, charge late charges for 1 month, and then add that to the balance for the next month, and then charge late charge on top of that. And so you don't kind of want to avoid the compounding late charge. And just really got determining like what amount is owed. So when you get that, then you got to figure out with the client, like what's the strategy here? Is it, do you want to get possession first and foremost? Or are you just trying to, shake some money out of them, get their attention? Maybe you don't necessarily want them out. Like what's the goal, so that we can figure out what our first type of communication to the tenant is going to be. Then the other thing I kind of look at when we first get the case is usually the first step is to issue a demand letter to the tenant in accordance with these terms. Often the client will say, "Oh, I've already done that. I've already sent them a letter. I just need you to file something." So you got to look at the client's letter and make sure that says everything it needs to say, which often it won't. Like for instance, when you're looking at is a tenant in default, can I exercise? So a lease will have typically a default section that tells like when they're in default, and a remedies section as to when I can then proceed to exercising my remedies. So you have to first figure out like, are they even in default? Under the lease. So, does the lease provide for some sort of notice and cure opportunity? Typically that'll be like a 5-day, 10-day, something like that. Often the lease won't say that. It'll say like, you're in default if you don't pay. But are they really in default if they don't pay? We'll kind of touch on that a little bit, in more detail in a little bit, but let's say the lease does provide for some sort of, notice and opportunity to cure, that at a minimum needs to be given. Then where do you send the notice to? Most often, if the client's doing the default, they'll send it to the address of the lease premises. But if you look at the lease itself, it'll typically have like a notice address in it that may often be different than where the premises is located. So you got to send it to the correct notice address. Because if you're a landlord and you're trying to strictly enforce the terms of the lease, which you should be trying to do, you need to also strictly comply with the terms of the lease. So send it to the proper location, and send it in the proper manner too, right? You don't want to, just send it regular mail or just send it by email. Most often it'll be some sort of, certified or overnight delivery that's required. Yeah, and then give them the notice and opportunity to cure. And then the other kind of component that we'll talk about is that, if you don't do that, let's say there's no notice and cure period required. It just says they're in default if they don't pay. And you go ahead and you file eviction. One defense that the tenant can raise is I'm not actually in default. That I have a history of late payment with my landlord. I've habitually paid late, they've habitually accepted it, and I've never been notified otherwise. They just continue to, they don't like it. They tell me, they send me some nasty emails. They tell me to make my payment, but they'll accept it 10 days late, 30 days late, partially, half and half. They'll accept it, by the time I get around to paying it. So as a landlord, when you're sending the default notice to the tenant, it's important you want to put this language in there that you're going to strictly enforce the terms of the lease. And I may have deviated from the course, in the past, I may have accepted late payments, but from here on out, that's not going to happen. I'm going to insist on strict compliance. And the reason you want to do that is this 1344, this kind of mutual departure language, because this is what a sophisticated tenant's attorney like David, he'll throw this in your face and he'll say, we've created a new agreement. There's a history of new payments that I get to pay 60 days late now. And so unless you kind of give them that strict compliance notice, you can't. In the courts, they're not going to necessarily buy your argument that they're automatically in default because they're late this particular month. So kind of all that being said, if you put them in default, then you've got to decide, like what sort of what sort of legal action are we going to file if they haven't cured? In a landlord-tenant situation, you can file a couple of different types of actions. A lease is just a contract, so it's interpreted and construed like a contract by the court. If you're trying to get money and the property back, then you would file an eviction action, a dispossessory. You can file those in any court. You can file them in magistrate court, state court, superior court. And we typically file ours in state court. For one, it kind of don't have to deal with a jurisdictional amount issue. But two, it also, if the tenant is an entity, it requires them to get an attorney, which is often easier to deal with than deal with the pro se individual. And it also kind of cuts out the appeal issue from magistrate. you can file an eviction, and then you can also file just a breach of lease case if you want to money only. Or oftentimes the commercial lease will have a guarantor. You just sue them if you want to try to get the money. They may be more liquid. The thing you want to kind of avoid is really doing it piecemeal. You want to be wary to not kind of get in piecemeal litigation where the client initially just wants to sue for the money, but then later changes their mind. They want to go for possession, because then you can get into all those stuff, res judicata issues, or, related proceeding issues. Dave, I think it's a good segue over to talk about.
Yeah, sure.
You've encountered.
Well, I would start off by saying this. In most situations where you are defending a tenant, you typically get notified that your tenant has an answer due tomorrow. Tenants generally have had problems dealing with their landlord over a period of time, especially in straight default, monetary default cases. I always contacted my clients who generally have more issues than just not having paid rent. The ones that are strict monetary default situations are generally applied under the general principles of contract. The way I first have contact with the client is I want to find out from them what are the issues that they have, and how do I build an answer for you that will allow you to stay in the property as long as possible. Most clients are looking to delay the eviction process and are looking for ways to negotiate with their landlord to be able to stay in the property. And so, first thing I want to know from the tenant is, what's your lease say? And have you been receiving notices from your landlord that you're in default? Then what are the issues in default? Are they only monetary issues, or are there other provisions in the lease that have been violated by the landlord that would give us defenses to the eviction action? Your client may want to delay the process of being evicted because they're moving somewhere else. They may want to delay the process because they just need to stay in there and make as much money as they can before they're evicted. In a lot of ways, the kinds of cases that end up in significant litigation have non-monetary default issues that have to be addressed. First process of acquiring the information from the tenant and then your client as a tenant, and then asking them what they want is part of the process of building the answer, because you only have 7 days to file an answer, and you can't open default like you would in a normal case. So when that 7th day is up and you haven't filed an answer, the landlord is going to be able to get rid of possession, and they're going to be able to go through the process of evicting your client. And your client won't have the ability to negotiate something with their landlord, either for a departure that would allow them to work through the monetary issues, or allow them a smooth transition to wherever they're moving to. One of the reasons Will and I are up there is we had a case in which, as a landlord, they filed a straight eviction action for monetary default. And when my client contacted me and I had to file an answer, the first series of questions I wanted to ask was, why are you being evicted? And the answer is, well, we haven't paid our rent in several months. Well, what else is the issue? Well, there are other issues that involve us trying to have gotten an assignment so that we could assign this lease to somebody else because we knew we couldn't afford to pay. So then the next step is to ask, okay, what kinds of notices were you given to let you know that the landlord was either willing to work with you or not willing to work with you on the monetary default while you found the process of maybe finding someone to take your space? That process of being able to file the answer to give that time period for a negotiation required me to look at what are the legal defenses that you might have. The first step, obviously, is reading the statutes. The interesting part about the distinction between commercial tenants and residential is that there's very few differences in the statutory scheme. We don't have a separate code for commercial cases, and issues that come up in commercial cases are a lot different than those that come in residential cases. And as you know, a lot of cases recently, we have the work areas where people live and work in the same place that they're renting. So Will's correct in his evaluation has to start with who's the landlord, who's the tenant, and what are the issues of default that would cause him to want to bring the eviction action. And as a attorney for a tenant, my first process is, how can I articulate in my answer those kinds of defenses that are necessary to put my tenant in an equal bargaining position or a better bargaining position with the landlord, so that we can achieve whatever the tenant's goal is. Tenant's goal is, I want to continue to stay, but I need to work out a payment plan. You might be looking at these mutual departure issues. Part that I always look at in evaluating any landlord-tenant situation is, a lease is a contract, and general contract principles always apply. If you're talking about a monetary default, you look first to the section that describes defaults. Are you looking for what the landlord's responsibilities are in notifying the tenant of their obligation to pay? Are there additional monetary amounts that have been added that were added improperly? Is there an issue with CAM? Because CAM is a very big part of a lot of the disputes that occur between landlords and tenant. Has there been a CAM reconciliation? Are the parties clear about what their rights, duties, and obligations are in notifying each other of what their expectations are? And because in a lot of cases, when the tenant is coming to a lawyer for the first time the day before they're going to be evicted, they haven't gotten good advice on how they should communicate with their landlord about issues that are non-monetary defaults. They have issues with repairs not being paid. They have issues with waste not being picked up. Other aspects of having a property, it's a commercial property, sharing that space with other tenants in that same shopping complex. Do you have a situation where there's a parking problem? Do you have a situation where you might be facing another tenant who does something similar to what your business is, and it's impacting your business? Is there something that's not something the landlord has done that's impacted the way your customers can get to you, like road changes or traffic pattern changes? But this all comes back to the idea that when your tenant client contacts you, the first step is to file an answer that gives you enough time to find out what the landlord is expecting of the tenant and if there's any possibility of negotiation. And so in the case that Will and I work together, the first time I get notice from my client there are issues beyond non-monetary defaults, I want to articulate in my answer to the very best of my ability all of my affirmative defenses. And if I have an opportunity to bring a counterclaim that might allow us to have more time to conduct discovery and other things that will, once again, try to keep the bargaining positions more equal if the purpose of the tenant having not paid is something that is not just a here. So what would you say is the next step once you receive a answer with all kinds of affirmative defenses and counterclaims and other issues that maybe your landlord has told you were issues between the parties?
If I get a reasonable attorney like yourself, pick up the phone, see if we can talk through it.
Right.
I think what David was saying, what all landlords attorneys fear, right, is the savvy tenant's attorney who can muck it up, right? Like delay this thing out as long as possible, so that possession isn't returned over for forever, and B, they don't have to pay rent. That's like always the worst nightmare, right? Trying to avoid that scenario. So, but yeah, like when if there are legitimate issues on the tenant side, I think the goal is to try to like figure out like can we work that out, right? I mean, do we really see things eye to eye, right? In our case, clients didn't see things,
Right.
Eye to eye. So we had to litigate it for a little while, but the issue in that case was, you probably are better articulating the facts on the tenant side than I am. But from our perspective, the contract was clear. Like we had a tenant that wasn't paying rent, and their excuse was, well, you didn't agree to accept our subtenant that we proposed. And we looked at the lease language and we're like, well, our lease language is pretty clear. Like we don't have to accept a subtenant if you're in default. I guess hard to read.
And Will, this is the interesting part of the first slide being 13.4-4. The concept of a landlord having a relationship with a tenant. The landlord has given them accommodations, has done things to try to keep the relationship going, to keep the tenant paying and being a performing tenant. Because in a commercial real estate context, having a performing lease is very important. If you're especially some of the larger clients where they have multiple properties, their interest is in trying to keep the tenant paying on time, being able to say that it's a performing lease. And when things start to go awry, the tenant starts paying late, the tenant starts paying partial payments. In more complex situations, those businesses know how to handle that. They know how to document, hey, we're giving you an accommodation, tenant. This isn't changing the terms of the contract. You don't have the right to say, I can pay anytime I want now. Lease says, and that's why it's important to be able to send the 13.4.4 notice before you start a eviction process. Hey, if we've done anything in the past that's outside the terms of this contract, please note that we're going to expect you to strictly comply with terms, including payment of rent. In our situation, the parties had in the past some mutual departure from the contract from our perspective. They had changed the way they conducted themselves. Instead of enforcing the exact rights of the contract, for instance, in this particular case, they had already allowed my client to assign a portion of their space. So you've already allowed an assignment
While they were in default.
And then at a later date, my client wanted to assign the rest of the property to a new tenant rather than default and not be able to pay. So from my perspective, my client was trying to do the right thing by finding a subtenant to take the space. And since they had already allowed it before, the process was, we can't pay our rent, we're in default, we'd like to assign this space. And since the landlord did it in the past, if they don't send the 13.4.4 strict compliance notice, the tenant's expectation is, well, we did it once, we can do it again. And then the question becomes in our process of our litigation, will a court apply the rules of construction of contract to a lease and ignore these mutual departures? Or can there be these other contract principles such as waiver, the other ones that I typically refer to? You know, the concept of exercising good faith in a contract requires parties to communicate about what their expectations are. One of them. If you're from the landlord's perspective, like you said, there's a contract, read the lease. Judge, read the lease and apply the rules that are in the lease. That's what governs the rights, duties, and obligations of the parties. But if you don't send a strict compliance letter, you leave yourself open to a tenant's attorney attacking that lease as having been departed from. And so that's why when you're building an answer, you're looking for all these affirmative defenses, because you want to be able to articulate to a judge why the lease is ambiguous. Because if the lease terms are clear and concise, and the parties have violated those terms, they're entitled to summary judgment. If you want to muck it up, or you want to be able to assert rights that your client has, that the contract has been departed from, you have to be able to articulate those in your answer. Then you have to develop facts that show that the parties in their conduct mutually departed from the contract.
And that's always the frustrating part on the landlord side, is because, you know, you'll get a set of facts and then the people on the ground dealing with the stuff, right? You got the property managers and the tenants, and they're just trying to keep life, you know, as easy as possible, right? They're just trying to work it out. They have a pretty familiar relationship. You know, they're talking all the time, you know, they're texting, whatever the case may be. And they're not thinking about strict compliance. I mean, they're just thinking about, you know, like, how can we just work out this issue that we have to work out? Right. So that's the frustrating part as a landlord's attorney, is that there's, you know, you'll get this set of facts where, okay, David's right to point out, like, you've already consented to a sublease previously where we were in default. And now we come to you again and we present you with a successive series of subtenants. You're not telling me under no circumstance will we do a deal because you're in default. You're allowing me to present, these subtenants. But then, at the 11th hour, 5 months down the road, you tell me, or the business people get wind of it and they look at the numbers and they're like, well, we'd rather, potentially not do a sublease for the remaining year term. We might prefer to do a new deal at a new rate with a new tenant. So then you all of a sudden notify the tenant that we're relying on this provision and you're not allowed to sublease the premises. But it creates a bad set of facts leading up until that point if you're on the landlord side. Because what you're trying to avoid is creating any sort of question of fact, right? You want the judge to strictly interpret 4 corners of the lease. Here's the default, here's the provision, we don't have to consent to a sublease. It's not unreasonable if you're in default or any set of circumstances that would lead to a default exists, which even gets you out of the realm of strict compliance. Nonetheless, you kind of have to you have to play the hand you're dealt. And if you get a bad set of facts, it can often be hard to convince the court to simply see that the 4 corners of the contract should be construed strictly. Like they have almost an inability to not just wander down this facts pattern and look at well, there is a prior instance of consent to sublease. And the other interesting kind of part about this is that not only do we have like a provision in the lease that says like, well, it's not unreasonable for us to not consent to a sublease. But we also have like a no waiver provision in the lease, right? That says like, even if we've, accepted, payments before or late, that doesn't constitute a waiver of the terms of the lease. So on the one hand, if you're a court and you're trying to construe the lease strictly and is there any ambiguity in the lease? On one hand, you look at a non-waiver provision like this, right? And it's like a no-brainer. Right? I mean, you're not waiving that right to reject the subsequent sublease, right? There's no waiver by course of conduct. But that's not what the case law says. I mean, the case law says you can waive an anti-waiver provision, which is mind-boggling, right? You're supposed to strictly construe the terms of the document, but on the other hand, the course of conduct, you can waive it. So then you get into like, okay, well, what the property manager say or not say, and you get into this course of conduct argument that, now as a landlord, if you're not winning summary judgment, I mean, you don't have to have a trial on this. You don't have to have a trial on did the landlord reasonably reject a proposed subtenant, because jury is going to be sympathetic to the tenant situation where we presented you, and you got to bring in the people from wherever, the corporate office, from wherever they were. So you've already lost. I mean, if you're a landlord and you lose out, if there's some question of fact and summary judgment, I mean, you've already lost. I mean, your client's annoyed. They're gonna have to have a trial. So, but they don't. It's important to educate your folks on the front end about a proper, course of dealing with the tenant. So if you're going to make a concession, how can you document it in a way that preserves your rights under the lease to say, like, even though I'm making a concession in this instance, that doesn't, create a deviation. That doesn't create a quasi new agreement under the lease. And the case law on this is remarkably on, what does and doesn't create fact issues in the deviation from non-payment. I mean, there's one case that says, well, summary judgment was properly granted to the landlord, even though the tenant was paying late, because at the time that they accepted the late payment, there was an expression of displeasure. Like what? I mean, what in the world? I mean, like, why? How can that not? I mean, how is that sufficient to, like, there's no question of fact? Like, how do you interpret the expression of displeasure? Like, it's just a lot of after the fact justification for really the judge to do whatever they want to do in this kind of fact pattern situation. So that's why you have to, try to just think about protecting your clients by, what is how can I belt and suspenders this thing so that we don't let savvy tenant attorneys muck it up, create questions.
So one of the things that I wanted to try to address today has to do with when your client has approached you about there being monetary default that they can't afford to pay and they still don't want to give up possession. How do you articulate to them what their rights are? And then how do you address with opposing counsel what your client's interest is to see if you can work something out? Because at the beginning of the process, they filed the dispossessory. You have 7 days to make your response. You file your answer. Now what happens next? Well, if you're the tenant, you want the court not to take up the case for as long as possible so that you can retain possession and deal with the monetary issues once the court addresses the possession issue. So when you're a landlord and possession is all that's important, you might be looking to work out something where the tenant leaves and isn't going to pay further amount or will pay a compromise amount. But if you're the tenant, you want to look for ways to either defeat the dispossessory at the get-go, which is to look in, did they make a demand for possession? Did they send the proper notice that they were required to under the lease? Have they failed in some fashion that makes their dispossessory subject to dismissal, so they have to start the whole process over again? And when you are trying to educate your client, they might have these defenses. You also have to take into account how is the landlord going to react to that? And then based on the fact that you have now filed your answer and counterclaim, you asserted these different contract principles as to why your tenant should either retain possession of the property without having to pay or can pay a compromised amount. Those issues of payment of rent are independent covenants from other covenants within the lease that the landlord may have violated. The landlord may have violated something that they were required to do, whether it's a repair of an HVAC machine or repair of a roof, something that truly impacts the tenant's business may be a good defense to not having to pay rent, but because they're independent covenants, you still have to pay your rent. So the landlord's first step, once I filed my answer, is to make the court make my tenant pay.
Yeah, so I mean, y'all familiar with it? 54?
Yes.
So this is an effective tool for the landlord when you have a tenant that files counterclaims, and often when the tenant files a counterclaim, it creates jurisdictional issues, right? So if the tenant's counterclaim is about a repair issue, they're probably going to bring some sort of injunctive claim as part of their counterclaim, which if you file in the state court or magistrate court is going to require transferring it to superior court. So in the meantime, use this tool, 44-754, to try to compel rent to be paid into court while this case is going on. So what this requires is that what is supposed to happen is that the tenant is supposed to pay all past due rent into court and all future rent as it continues to accrue, but only if they want to remain in possession of the premises. So if they don't want to, if there's too many issues or they can't afford to, and they just want to vacate, then the statute doesn't really apply. This is only applicable if the tenant wants to remain in possession, for the duration of the lawsuit. Which, it's tough on the tenant side. I mean, I sympathize, to some extent with it, because if the part of the reason you're saying you can't pay rent is because of the condition of the premises or something the landlord did or didn't do, then it's a tough thing to say, well, okay, we can litigate that, but you got to come up with all the past due rent if you want to stay, in the property to do so. And so there's almost like, there's almost a mini trial that occurs often, when these motions are filed, where the judge has to hear evidence of what the rental is, why it's contested, and what amount is appropriate. Now, the rent, if it's undisputed, should go directly to the landlord, like pay to the court, but then it can be dispersed to the landlord. But if it's in dispute, if there's some issue as to, well, tenant has counterclaims for damages too, then it may sit in court, it may stay in court. So you'll still have to pay the rent in court. It'll stay there until the case is finally adjudicated and the judge will disperse it to whoever filed for it to be dispersed to. And then the other thing to know about this is that if such an order is entered and the tenant, doesn't make the payments, then a writ, automatically issues. And so writ of possession can automatically issue, even though the case is still ongoing, even though the merits of the case are still ongoing. And then that's, very difficult to appeal that at that point with the possessor, the possession issue. It's just a violation of court order, right? So it's not directly appealable. You just violate a court order, so then the possession issue is off the table. And you're feel free to litigate the rest of the case, but your business is that you lost your business. Whatever improvements you made to the premises, and that's really on the tenant side, that's the difficult consideration for them, right? Is they may have they get plenty of calls from situations from tenants who they've invested a significant amount of money into building out space that they don't own. And then, there's construction reasons why they haven't been able to open. And then, so you get in a situation where maybe they have a little bit of runway to pay rent after the rent commences, but then, ultimately they can't really get the business up and running, because of something allegedly the landlord did or didn't do. And, then they're met with a dispossessory, but they've invested all this money into it, but they can't get the business operational, and they lose out on the opportunity to even enjoy the business, even though they have counter. So 44-754 is a very favorable landlord tool for to kind of use and keep in mind dealing with eviction cases.
And so one of the issues from the tenant's perspective is if the landlord has gone through the process of filing a motion to ask for the court to compel rent, the important part of reviewing what your defenses might be to that, you look at the statute, you read the statute, you understand that the statute requires the court to determine what is considered undisputed rent. So you can, as a tenant, have a dispute over what rent is actually due at that time as a matter of undisputed rent. And so they file a motion. Does that motion get handled by the court where there's 30 days for me to respond? It doesn't say in the statute. Each court kind of handles these motions different, in a different manner. The statute says that issue of possession cannot be determined within 2 weeks. This is supposed to be an expedited process. The courts are supposed to put these on the calendars immediately. When you're dealing with residential cases, the magistrate courts sometimes have 3 hearings a week, 3 hearing dates a week. You can always get on a calendar. But if you filed your action in state court or it's been appealed because of a counterclaim to superior court, a lot of those judges aren't equipped or haven't dealt with these cases before, and they may get a motion to compel rent, which should be heard in an expedited fashion because it's a shall. They shall issue an order so that the landlord is secure during the process of the litigation over the other issues in getting their rent on a regular basis. As a defense attorney, you're going to want to have that process delayed as much as possible. You want to articulate to the court that you need time to respond to the motion, that you believe you might get an affidavit from your client as to why rent is disputed. The court should hold a hearing, but does not have to hold a hearing to determine whether or not rent should be paid into court. And then once rent is required to be paid into court, can you convince the court to give you extra time? If the past due rent is a significant amount of money, you ask the court to break that into different time periods. And that order, once it's issued, if the tenant doesn't pay, they have to give up the right of possession. But that's not going to happen the very next day. The landlord's attorney still has to get the court, once they've issued the order, to then find the tenant having not paid, having violated the order, to issue the writ of possession. And not all state or superior courts have handled enough of these kinds of cases where they know that it's the day after the tenant doesn't make the payment, they really should on their own issue the writ. Or if the landlord's attorney sends a files proposed order, that order should be executed fairly quickly, because the process, once you have a writ of possession, doesn't mean you can go and change the locks. You still have to go through the process of getting the sheriff to serve and keep the peace while you remove the belongings of your commercial tenant who does not want to leave. That's the process of filing a motion to compel rent does still give the tenant opportunities to defend and delay. And during that process, that's when I believe you advise your client, here's your opportunity to make your best pitch to the landlord for either allowing you to pay smaller amounts of money, changing the terms of the lease, working on a lease amendment. It allows you to retain possession. But if you're a tenant, if your tenant just doesn't have the money, is never going to be able to pay, they're going to lose possession of the property. And the case is going to change from whether or not possession is an issue to how much is due. In a lot of cases, because it's a commercial lease, there's also a guarantor involved. And because there's a guarantor involved, as the lawyer for the tenant, you want to make sure everything you're doing also thinks about the impact it will have on the guarantor. So it's at that point that the landlord's attorney has to make some decisions about when do they bring the guarantor in, if they've already got possession, what's their game plan for obtaining a judgment and going after a tenant who may have other locations or whose guarantor may be creditworthy, and you want to make sure you preserve and protect your right to collect against them. So what would you say is your next step?
Yeah, I mean, I want to say one more thing about this too, is that this came up recently, surprisingly to me. But when a judge enters an order to compel the tenant to pay rent, that's not like a judgment. That's not an award of rental to the landlord for, in the case. That's only a payment that's required if the tenant wants to remain in possession. I had an attorney argue to me that that order was because my client, I was on the tenant side in this case, but because my client didn't make the payment, that they had violated a court order, and it was like sanctionable, because it was a court order to pay rent. And I was like, well, the statute says that the remedy is to give you lose possession. There's not like a monetary sanction, but I think that's an important distinction too. I wanted to ask you, David.
Yeah.
Have you ever successfully gotten the amount of the past due rent to be different than what the ledger said? Have you ever successfully argued a different amount?
Yes, I would. What I would think is that in a lot of cases, the amount of rent that's due is very hard to articulate to a judge why. It's because they're independent covenants, that amount isn't undisputed. But it's a lot of the other charges that are insisted upon by the landlord that may have created this conflict that's resulted in this eviction, whether it's additional CAM that's being charged, late fees, or other expenses related to work that the landlord did on behalf of the tenant. Sometimes there's a repair issue the lease requires the tenant to be responsible for, but the tenant doesn't do it. So the landlord has the right to step in and do that, and it becomes what's considered additional rent. And then those are the periphery monetary issues that would get litigated in a 44-754 motion to compel rent.
So you've been able to get those excluded.
I think that I've been successful in convincing the court we're talking about rent.
Yeah.
And that
Because the statute doesn't say anything about CAM.
doesn't say anything, but your argument obviously is that some commercial leases, the more sophisticated commercial leases, have covered a lot of these issues. They've put in anti-waiver language. They've put in, if you're gonna have an assignment, you have to be current on your rent for the landlord to consider it and to do it in a reasonable manner. The landlord can enforce different rights that are in more sophisticated commercial contracts that would require these additional monies to be considered additional rent. And if it's additional rent, then it's considered undisputed. But I think what I'm describing is if you're an attorney for a tenant and you're trying to delay the process so that the landlord is willing to work with you because you need a change to your lease or you need a way to work something out because you can't make all the payments right now, showing the landlord that this could be delayed 6 months while you're doing discovery, and yes, we'll pay the rent into court. The statute does talk about whether or not once it's paid to the registry of the court, who should receive that money and how soon it should be released to the landlord. But if the landlord needs that money right now, letting it sit in the court registry until the case is resolved isn't going to help that landlord. So I'm looking for a button to push with the landlord that makes the landlord more willing to work with my tenant where in the past they weren't. Maybe they had worked with them in the past and the tenant hadn't complied with whatever they agreed to, and there's no trust level. So there's an opportunity to put something in writing that requires the tenant to do something with the threat of them being evicted. And the landlord might be more willing to accept a written forbearance agreement or a written settlement agreement that does a couple of things that helps the landlord. And one of those things would be not to be able to appeal it, not to be able to delay possession simply because there's an appeal. There is a big distinction in kinds of cases that get litigated between strict monetary defaults. There's not a lot you can do as a landlord tenant to a tenant's attorney to defend them if they owe money and they just can't pay it. It's these other issues that arise that do create litigation that will delay a landlord from recovering possession of the property, and they have a lot to do with non-monetary defaults. And because the contract itself, the lease, governs the rights, duties, and obligations of the parties, I've always looked to litigate based on general contract principles. I'm looking for within the lease there to be ambiguity so that the court has to apply rules of construction of contract before they determine what my tenant's rights are. And if you look at the rules of construction of contract, because a lease is a contract and the arbiter of that lease is going to be the judge, you're not entitled to a jury trial because the judge is just going to apply the rules of construction of contract, even if there's an ambiguity. If there's no ambiguity, the judge is just supposed to look at the terms of the contract and apply them. So as a tenant's attorney, you're looking for ambiguity in the lease that you can argue would require the judge to apply rules of construction of contract. And if they can't resolve the ambiguity, then you get a trial, which obviously allows you to articulate what you think your rights are in front of a judge or a jury and maybe argue some of these other principles. There was late intermittent payments. There was no strict compliance. There was a mutual departure from the contract that gave the tenant the expectation that they could pay late or they could pay less or that they could assign the contract. A lot of the principles of construction of contract all come down to the number one principle, which is what is the intent of the parties. And if the lease itself is ambiguous and you can make these arguments about mutual departure, you might be able to win or be able to retain possession by making payments if you now are in a position to make payments. I think that the hardest part about having the non-monetary defaults is that if your tenant can't make the payments into court and they lose possession, they can't generate enough money and the whole case falls apart. So you have to find a way to retain possession as long as you can until you can either work something out or your tenant can move on to another location.
We're good.
Yeah, you're still good, for another.
Oh,
Yeah.
5 minutes. You're talking about demand.
Yeah, we have a question.
Yeah, hey, one of you guys mentioned earlier about you only have 7 days to answer, you can't open a default, which I get. Does that absolutely apply also to the monetary damages if specifically you're in default? You don't answer, you owe whatever they allege in their complaint?
Oh, yeah, if you don't answer within the 7
days.
Yeah, if you're suing for past due rent and.
Yeah.
And for, and the reason is that, when you file dispossessory affidavit, it's sworn and under oath, and the code says that, it's essentially liquidated. So if you miss the answer period, you owe that.
And your question is a good one, because if you're aware of residential, you file an eviction action, you want the court to terminate the lease, and if the tenant is served by tack and mail, you cannot get a money judgment. Same thing applies with commercial cases. If you don't have personal jurisdiction, either by them being served personally or by having them file an answer and subjecting themselves to the jurisdiction of the court, then you can't get a monetary judgment. Part of the process of a landlord's attorney trying to determine what the best course of action is for their client is that if you do have a guarantor or you do have a situation where the money matters and you think you're going to be able to collect it, and all you're trying to do is get possession, then you want a tack and mail situation, and you want to just be able to get possession and then deal with the monetary issues later. Because if you don't have possession, you don't know what kind of damages you have in terms of physical damage that you might be entitled to collect. So there is a consideration that has to be made. Do I want the tenant to answer? And as the tenant, do you want to answer and subject yourself to this jurisdiction and fight the monetary issue along with fighting the possession issue? If your tenant is moving, or there's a situation, as I've described, where the landlord's supposed to repair the roof and hasn't, and you've asked several times, what do you do as a tenant at that point? Do you declare a default of the lease and then sue for breach of lease? Your argument, the landlord has breached the lease first, and I'm excused of my obligation to pay, but I still have possession, so I have to pay something for my possession. Are you entitled to offsets? These are all considerations that are made when the landlord's attorney decides to file, what court they want to file in, and what they want to assert. As a tenant's attorney, first thing I want to know is, do I have defenses? What does my client want to do? Do they want to retain possession? Are they looking to have a negotiation with the landlord that they couldn't have before? And do I need to level the playing field by looking towards these defenses? Did they send a strict compliance letter? Was there an issue that I can grab onto, that I can describe to a court as to why this isn't a cut and dry situation of monetary default, just give me possession?
Quick follow-up. You get personal service, commercial lease, the tenant doesn't answer within 7 days. They're in default, they're evicted, and they also owe $300,000 or whatever's alleged. Does the court have the authority to open that default? And have you seen that happen? I mean, seems like pretty onerous.
I don't believe the court has the ability
There's no open default.
open the default, the monetary, so the landlord.
You have to collaterally attack it somehow, right? You have to set it aside by saying that some sort of reason that the judgment could be collaterally attacked.
It's a breach of contract action, but you only have 7 days to answer with no.
Yeah, it's great.
It's a little onerous.
But the landlord has the ability to seek personal jurisdiction, and if the tenant doesn't answer, then and if all they want is possession, then they can delay the concept of getting monetary damages. But the monetary damages that they're due is only through the date that the lease is being terminated. Some commercial leases allow for continued collection of rent in the future. And there's always been this discussion about, do you look at that stream of, like, there's 4 more years on a lease. Do I get to collect all that money for the next 4 years? What mitigation issue? So one of the things as a tenant's lawyer I'm always looking at is the duty to mitigate. There's no duty to mitigate unless you have the opportunity to mitigate and then you decide not to. One of the cases I put in the materials is if the landlord takes possession and gives it to their uncle to use for the next 4 years, you can't charge them for rent for that. It seems obvious, but that's a question of mitigation of damages. Because at the time you're getting your money judgment, none of those things are going to be addressed. You actually have two cases. I think you have two cases for damage. You have one through the dispossessory process, and then afterwards you have another claim for the remaining damages.
All right. And then folks, we are back. Thank you for the break. And we have with us today Judge Vincent Lottie, the Chief Judge of Henry County State Court, also a native Georgian like myself, and also a UGA graduate like myself. And this segment arose because of a day I spent in Judge Lottie's court, watching him deal with a unique kind of a human, well known to some of us. I'm going to turn it over to Judge Lottie and let him introduce. We have got a 2-for-1 deal today as a bonus for you. So thank you, Judge Lottie.
Thank you, Mr. Cleveland. Can everybody hear us okay if we stay here? Are we good? Okay. So, yes, my name is Benny Lottie. I am the Chief Judge in Henry County. Thank you guys for having us. Mr. Cleveland got to witness a fun day in court, actually, when he stopped by to see me, and I was in the middle of a criminal calendar, and I had a sovereign citizen. And so Judge Bowles has been kind enough to come with me. This is James Bowles. He was appointed to the state court bench 8 months ago by Governor Kemp. Prior to that, he served as a partner in the law firm of Sexton and Moody, also located in McDonough, and he's been practicing about 10 years before he took the bench. And so he joined us at state court, and he immediately got a welcome into the world of sovereign citizens as well. So has anyone here had the pleasure of dealing with a sovereign citizen? Just about everybody. Perfect. Well, before we begin, yes.
How do you like to greet a sovereign citizen?
Same as everyone. Hi, how are you?
You don't say welcome aboard?
And we will get into that later. But yes, they do like to quote maritime law. One actually said to me one time, we are all dead until proven, we are all dead at sea until proven otherwise. And after a quick look at my floor, I saw no bodies of water and decided that I would deem him alive. So, and we kept going. So yeah, and that's Judge Bowles and I talked, and we know that if you deal with a sovereign citizen, you either have a story, an anecdote, or a question when dealing with them. So we have structured this more of like a conversation while we cover the material. So please feel free to ask questions as we go. But we thought we'd start it off with a little video that you can kind of see what we're dealing with. So if you don't mind playing the video.
Especially at this time to address preliminary. I haven't finished, sir. I haven't finished what I'm saying. Can I please finish? Can I please finish what I'm saying? Because what he's doing right now, this is not sovereign citizen stuff. He's not allowing me to say anything.
All right, Mr. Clay, I'm holding you in contempt. You're disrupting my court testimony. So that was an individual that had appeared in court who the new thing is now is they don't want to be called sovereign citizens. That is their new thing. I'm not a sovereign citizen. So that interaction you saw was actually between me and an individual. He was illegally recording in my courtroom, later posted his illegal recording to TikTok, and began to, of course, try to get people rallying behind him, which they did. And so, the first thing I did when I saw it was I laughed, and then I immediately, like everybody else would do, I went to the comments. Right. So I said, let's see what we're dealing with here as far as what he's getting back his feedback, because he had over 500 comments. So these are some of the comments. Sue the judge for slander and discrimination. He called you a sovereign citizen. Contempt does not exist under 42 USC. File a misconduct. This is a violation of your freedom of speech. Immediately make a change of venue and take this to federal court. Remind you he's here on a failing to obey a stop sign ticket. That's 100. Okay. This will. Going to court to claim you're free is like going to your enemy's house and expecting them to fight fair. Read the Universal Postal Code. The court, in quotations, begins when someone mails you a fraudulent document claiming you owe a debt. These are legitimate comments from people who truly believe these things. Let's see.
I'm sorry, are you going to address the one about the JQC? Because somebody even that existed was impressive.
Yes, there is one that says to call the JQC, but they're corrupt too. I was impressed that that they knew what the JQC was, but then they later go on to talk about how they're corrupt and they cover for us judges. Latonia here says he violated your due process, which is your constitutional right. That's how you break his immunity. But the JQC is hard to do for complaints. You need to go to the Supreme Court because the Supreme Court is going to hear sovereign citizen arguments. Here's one of my favorites. He just created a hostile environment by holding you in contempt. That does tend to create hostility. You must give written notice. Let your paper speak for you. The problem is all the paper that they file is useless and it's nonsensical writings. And so, he goes on to say, well, I filed written notice, which he did. And then he proceeded in his criminal proceeding to quote the Georgia Civil Practice Act. And when I tried to explain to him that his rights under the Civil Practice Act do not apply in a criminal proceeding, that was just not something he was going to wrap his mind around. All laws apply equally. And then we go down a little bit more. The very last one here. Yes. Get his bar number, find his oath of office, and then sue him federally. Then give the order to the court. They still got paid off of you. And so there are 500 more comments under this video that go on into this nonsensical sovereign talk. And like I told this gentleman, when I called him a sovereign, and of course, the second you call them a sovereign, they're going to get massively offended. And I told him in open court, I said, sir, you are telling me to look at a pond and to watch the thing moving across the top. And it's got webbed feet and it eats fish and it's got a beak and water's rolling off its back and it's got feathers, but you're telling me it's not a duck. It's a duck, no matter how you phrase it. You're a sovereign citizen no matter what you call yourself. Whether you're a member of the Moorish tribe, which is a new thing that they're trying to do, that they've changed their name under the Moorish tribe, so they're not obligated to appear before the court or to pay back their debts, because that's not them. Because the Moorish tribe has acknowledged them as a citizen of their tribe, and that alleviates all legal responsibilities, right? And so these are some of the new tactics as they went down the sovereign citizen road and found out that all those roads lead to one place, which is whatever your local jail's address is. They decided that they were going to mix it up, right? And so that begs the question, where did this movement come from? Like, how are these people so brainwashed? I do a lot of work with mental health. I'm convinced that this is a mental health issue. These people, and a lot of times the people that this movement targets do have mental health issues. A lot of them are impoverished. A lot of them are very vulnerable mentally, and they attack this, right? So and in Georgia, and at least south of Atlanta, what we predominantly see is this movement in the African-American community. We actually have a community of sovereigns that live over towards the Hampton area that is basically a sovereign commune where they all live and share and they govern themselves. And so, I found it paradoxical as to the fact that this movement is running rampant among the African-American community, especially when you know the origins of how it started. And Judge Bowles is going to talk to you a little bit about where this movement started.
Thank you. So the start of the sovereign citizen movement comes from an organization in the late 60s called posse comitatus or comitatus. It's Latin, which is interesting, is you will find that most of these people seem to be well-read in something, we just don't know what it is. They spend a lot of time and valuable resources learning about things that aren't actually, well, true. I mean, that's really what it boils down to. If the average sovereign citizen probably put as much work into learning the tactics of a sovereign citizen as they did into learning real law, they could probably be really good lawyers. But unfortunately, they don't. They go off on this tangent. So that organization started with a belief that county government was the highest legitimate authority. And I'm going to place that in quotations, legitimate authority, because you're going to, that seems to be the idea behind this, is that the court, whatever court it may be that they're appearing in front of, and I'm convinced it could be the United States Supreme Court, would not be a legitimate authority. Some other court is a legitimate authority. You'll find that they'll cite the code sections of those other courts or things that are applicable to those types of law, but never the types of law that they're actually arguing on behalf of themselves for. So they believe that county government was over federal government in terms of legitimate authority. And a lot of this was founded in anti-Semitic and racist views. So that shifts into, ironically, from going to the federal government has no authority and the county governments have no authority, we go to the tax protesters movement. Now, tax protesters believe, of course, that the federal income tax is illegal and it's unconstitutional. And what they would often do, and we still see this same trend, is they would misinterpret legal code and misinterpret the Constitution to fit what suits their arguments. And, you know, commonly what we see is citations to the Universal Commercial Code and maritime law is indicated. You know, I am not a driver on the roadways. I am a traveler. We hear that sort of thing all the time.
I'm not engaged in commercial business.
Right, exactly.
Under the UCC. I love the UCC.
Okay, so we go from, we have the tax protesters subsect, and then we have the subsect that have developed these opinions out of racial bias. Now, where that comes from is an individual named William Potter Gale. William Potter Gale was a World War II officer, and he later became an Episcopalian preacher. And he had ties to the KKK, and he was under the belief that white people were white Christians specifically, were the true Israelites, and they were entitled to special treatment, and therefore they were not required to pay taxes. Now, the interesting thing about William Potter Gale is he was, of course, arrested for not paying taxes and for tax evasion. And while he sat in prison waiting on his appeal, he passed away. So this man truly died in prison over his belief that he didn't have to pay taxes, which is horrific. Another big individual in this similar movement is a man named Irwin Schiff. Irwin Schiff had a similar belief that the federal government's authority was not legitimate and that paying taxes was unconstitutional. So he believed he didn't have to pay taxes as well. I don't know that he met his demise while sitting in prison, but likewise, he went to prison for not paying his taxes and for tax evasion. So if you're sensing a trend here, that's because there is one, interesting enough. So I was talking with Judge Lottie, and I thought it was really interesting because a lot of the foundation of the sovereign citizen movement started with the federal government is not legitimate. The federal government has no authority. But it seems that it's actually shifted in modern day society, and we'll probably get into that a little bit in discussion of what the sovereign citizen has turned into post-internet. But it has shifted from the federal government is not legitimate and has no authority to now the state and local governments are not legitimate and have no authority. And we're citing federal codes in criminal court. We're citing the UCC, or we're citing, things that don't apply when the applicable statutes and what we're actually being prosecuted on, or the laws as related to civil matters such as criminal collections, are in fact state codes and that sort of thing. So I thought that was an interesting paradigm that this whole movement was started in the idea that the federal government was in fact not legitimate. And now it seems that the federal government is in fact the only thing that's legitimate. I want to give you a couple of anecdotes that I've thought were pretty humorous. In regards, so I was a criminal defense attorney for most of my private practice, and I was in court before one of our superior court judges while she was dealing with a sovereign citizen one day, and it's you never see these people. They don't come in, make a sovereign citizen argument, pay their ticket, and leave. They ride your calendars for as long as they possibly can, months and months and months. So, of course, this is not the first time this particular judge had dealt with this person. And he's making sovereign citizen arguments, and he's being non-compliant, and he's being argumentative. And we're just at a calendar call. Just tell me if you're ready to go to trial or not. But he's just going and going. And the judge is holding him in contempt, and they're going to take him into custody. And he's fighting and everything else. And we're instructed by our security, our bailiffs, and our deputies that when things start to get out of hand in the courtroom, we got to get off the bench. For our safety, get off the bench. So the judge stands up and she's walking out to get off the bench. And he's being placed in handcuffs and struggling and screaming. And he says, and I'll never forget it, he says, "The judge has abandoned ship." All right. That's about the reaction we got out of
I wish these stories were fake, guys. I really do.
More applicable to the credit collection side of things. Of course, we deal with collections and civil matters. That's probably this forum is where we would be most likely to see sovereign citizens within our civil calendars. I've only been on the bench since June. I have actually had limited interactions myself with sovereigns, but one that really stands out to me, and I think it may have been the very first one I had. He was appearing on Zoom, and we'll just say his name's John Smith. I don't remember his name. But on Zoom, and his name on the Zoom is John Smith. Well, I get to his case, I call the case and call the case number, and I look to the Zoom, and he unmutes himself, and he says, "Good afternoon. I'm appearing on the estate of John Smith." And he starts to continue talking, and I go, "Wait a second. Are you telling me that Mr. Smith is deceased?" And he said, "No, he's not." I said, "Well, and you're only appearing on his estate, so I'm going to presume that Mr. Smith is not going to be joining us this afternoon. So that default will issue. You're free to log off, sir. Have a good day." and I started calling the next case number, and he goes, I hear him on the Zoom, "Oh, is that's it?" And I went, "Yes, sir, you can log off." Call the next case, and he just goes, "Wow." Well, there you go. That's how that's going to go.
And that's the common theme, right? And one of the things Judge Bowles and I were talking about is, right, it's not coincidental that this movement began in the heart of the civil rights movement in the, mid to late, from the mid-60s on. And a bunch of white supremacists wanted to say that the federal government wasn't legitimate, right? And it's because they wanted to be able to act with impunity on their racist beliefs. And so as things have gone on, that has clearly shifted. And I think the big part of that is the internet, right? Because time has passed, less, the Klan and white supremacists cannot operate out openly. So that part of it has kind of subsided. And then you have the internet. I did a quick Google search earlier and just typed in sovereign citizens on Amazon, not Google, excuse me, Amazon. And it was just book after book after book after book on how to be a sovereign citizen, the arguments to make, the Constitution and you, how to win as a sovereign citizen, right? And so with the information age now, they have been able to reach the masses to peddle this ridiculous thought process of they don't have jurisdiction. One guy asked me one time, "I need to see where you have jurisdiction over me." I said, "No problem. Get on I-75 North and drive to see the building with the big gold dome. If you go in there, you'll see a book and my name's in it. Go check it out." Right? Because that's one of the things I always want to challenge is jurisdiction. And so how does this come over to civil? It used to be we never saw a sovereign citizen in our civil proceedings. They were always criminal. Now, I've had 2 or 3 in the past month. Judge Bettis, our newly appointed 5th judge, had her first ever civil calendar 2 days ago, and there were 3 sovereign citizens on it. And so they're going more and more and more with the sovereign citizen argument in the civil war. And they're always saying the same thing. They're challenging service. Well, I wasn't serving. Well, I have an affidavit here saying you were. Well, that says I'm 6'1", I'm 6 foot. That is still sufficient, right? And so they take it too far, then I have to call in and I have to have a hearing on whether or not they were served properly. So they're challenging service. That's going to be a big thing that you're going to get. Venue, jurisdiction, and the other big thing, especially for you guys that you're going to run into, is they're going to start telling you all this just silliness about how they owe Capital One the money. They don't owe Midland Credit or LBNV Funding or whoever the money because they didn't enter into a contract with them. They entered in, and it's illegal and it's against the Constitution. I'm like, the Constitution isn't worried about where your debt's being sold, okay? And so that's what they're challenging, and what they're doing is they're making you have to jump through the hoops of having to show here's the chain of how your debt was sold, and here's the contract you signed originally with Capital One that says if you default, they can sell it, right? And so those are the things that they're challenging, but they're using all the same arguments, whether civil or criminal, all the same thing. No jurisdiction. You're going to get a lot of that. I'm appearing specially. No, you're not. And I tried to explain to them, that's a civil thing. That's not a criminal thing. You don't get to appear specially in criminal. Well, under code 911, yeah, that's awesome. You're right. And if this was civil court, I would listen to you. But you're here on a stop sign ticket. Funny ending to that story is that gentleman came in for his jury trial. Because what you heard me say in the video was the day before that video was filmed, we had a motions hearing day, and I let him get all his sovereign citizen out, which I normally don't do. But I told him on that Tuesday, when you walk out of here, I'm done with the sovereign citizen stuff. I'll let you get it all out of your system. When you come tomorrow for calendar call, I'm not putting up with it. You start doing all this stuff again, you're going to jail, right? Right then. So he comes in, immediately starts. I said, yep, we went through all this yesterday. We're not doing it again. I'm putting you on the ready list. I'll see you next week for your jury trial. Of course, he doesn't stop. I hold him in contempt. He goes to jail. He comes back that next Monday morning after he gets out of jail for trial. And I tell him, I need you back at 1:30. We're going to start your trial. I'm going to handle pleas this morning. 1:30, we're picking a jury. He says, okay. He comes back at 1:30. This time he's got 2 older women. So I called. I said, all right, I'm about to bring the jurors up. Are you ready for trial? And he said, well, I said, but look, before we start trial, let me go over a couple things with you. If you start this sovereign citizen stuff, I'm going to hold you in contempt again. And I'm going to add that to whatever sentence I give you if you're found guilty. The other thing is if you continue down this road and you don't stop, I'm going to remove you from the courtroom and I'm going to have you taken to another courtroom and you'll watch the proceedings while your elbow handles your trial. And I'm watching the 2 older ladies do this. Now, I don't know at this point if they're on his side with the sovereign thing and they're thinking I'm the biggest jerk ever, or they're thinking he's the biggest jerk ever. So I said, you want to take a minute to think if you want to accept the state's deal? He said, and the older woman slaps him. She said, you do? And he said, yes, sir. He comes back in and enters a plea. His grandma took him out in the hallway and told him how stupid he was. He came in and entered a guilty. After all of that, he ended up spending, I think, what did I hold him in contempt? 3 times. So he ended up spending 30 days in jail on a stop sign ticket that would have been a no-low plea and a $160 fine. Because he was so just stout that what he was saying was right, and I was wrong. And I didn't know the law, and I have no venue over him, and I have no jurisdiction over him. And he kept making the motion to dismiss. You're going to get a lot of these. Haven't proved venue. So that has to be proven at trial. That's not something that has to be proved pre-trial. That's what the jury's for. It's an element of the crime or the element of whatever of the case that has to be proven at trial, just like every other element. They're not bound to prove it yet. Yes, they are. No, they're not. Well, I read that they are. Well, I read that somebody saw a pig fly. It doesn't make it true. And so they dig their heels in because they truly believe this. And like I said, what you're dealing with most of the time is people of limited resources, limited money. Most of them, you're going to find 1 or 2. One is going to be like this guy who's actually pretty intelligent. And he knows just enough to be dangerous, but he focuses it on the wrong thing because he is so, it has become a cult. They believe this the way that, religious cults believe what they believe. It's the same type of of scenario and the information age, the ease of access to these people who are preying on them and selling them their books and their online classes and their in-person classes, they're continuing to perpetuate this. I mean, this is like a Jim Jones, David Koresh type mentality of they are all in and nothing you say is going to convince them. And so how do you identify the sovereign, right? Obviously, some of them you're going to know right out of the gate. Just as soon as they open their mouth, you're going to go, got it, sovereign. So some of them are not so vocal about it. They do it in their pleadings. And so you have to look at the pleadings, right? You'll find random Bible verses in there that will 100% be in there with almost every single time, as there's going to be some Bible verse about how, only God has the ordained jurisdiction or the ability to judge a person, and that the court's not recognized as a proper authority. So you will definitely see that, or like Judge Bowles was saying, they're immediately going to start citing things that mean nothing to your case, right? And it's funny because when they're in the criminal world, a lot of times they cite the Georgia Civil Practice Act. Okay, when they're in the civil world with you guys, they're going to start citing the UCC maritime law, which they use maritime law a little bit. Like I said, I had a guy tell me, I asked if he was who he was, and he said no. And I said, okay, well then, deputy, take this man into custody for practicing law without a license. And he said, well, wait, Judge, no, I didn't say I wasn't him. I said, no, you did. He said, no, I said that I was here on his behalf. And I said, well, unless he's dead, you're not here on his behalf because there's no for the estate of. And I said, well, unless he's dead, are you dead? And that's what he said. Well, Judge, actually, we're all presumed dead at sea until proven otherwise. Serious as a heart attack.
Gotcha.
And of course, the prosecutor dies laughing, and it took me a minute because I couldn't tell if he was serious or not, or if he was messing with me. And no, he was serious. He was 100%. He truly believed that there was a law, and he cited like the U.S. Maritime Act of 1782 or something, and was like, "Yep, if you look there, you got to prove that I'm not dead at sea because we're all presumed dead at sea." And I'm like, "What are you talking about?" But what was more concerning was that he was all in on this idea. This was not nonsense. This was not gibberish to him. This was truth, and I had to prove otherwise. And so you're going to see those type things in the pleading. Another thing you're going to see, Judge Bowles and I were actually talking about this yesterday as we were preparing for this, is you are going to see, and Adam, I know you've seen it because you specifically asked me to talk about it, and I wish I could tell you more, but you are going to see on probably 50% of the sovereigns you deal with an inexplicable red thumbprint next to their name.
Colon in their name.
Yes.
Near, one of my favorites is the near. They don't recognize political subdivisions.
Correct.
And so they'll say, they won't put the city, they'll say near the name, or they'll put the zip code in brackets.
Yes.
Because they don't recognize political subdivisions.
100%. 100%. And I guess somebody has told them along the way that you have to use this red ink and do a thumbprint in order to, offset your appearance or something. I asked one of them, why do you have a red thumbprint? And even he couldn't give me an answer. So I think somebody just told one of them to do it once, and it spread like wildfire on their internet forums and, whatever book they bought off Amazon. And it just took off. If you see that red thumbprint, you are 100% dealing with a sovereign citizen. Okay, they are going to now, and like I said, that's the new thing is they figured out sovereign citizen doesn't work. So they are going to tell you it is offensive to call them a sovereign citizen, and then they are going to quote everything a sovereign citizen would quote. Right? And so I don't know where that comes from. Same thing with the copyright symbol next to their names. Like you don't have a copyright on your name. But they argue that under the UCC, their name is trademarked to them. And I'm like, well, just a second ago, you were telling me that that person doesn't exist, that you're a natural, which one is it? And I asked one of them one time, this was actually recently, I think you were in there for this. He was making his sovereign arguments about how the law is illegitimate and all this other stuff. I said, let me ask you a question. And he said, okay. I said, if you leave this courtroom right now if I agree with you and I say the law is illegitimate, you're right, it doesn't apply to you, you are free to go. And you leave and you get in your car and you go up here and you turn left right here on Jonesboro Road and a car smashes into you. And you are hurt, man. You are banged up. You got a broken arm, broken leg, right? Are you going to sue that person? And he said, well, I mean, yeah, I'm hurt. And I said, well, I thought the law was illegitimate and didn't apply to you. Right. And he said, well, I said, now the person who hit you can be charged criminally because it applies to him. I said, but if I take your argument as true, you can't then come back in here and ask me to punish or ask a jury to punish this man for hitting you or for an insurance company to pay you because you don't believe in the law. So under your belief, he doesn't have to have insurance because the law doesn't apply. So you're not entitled to any of the money, right? And he just kind of stood there and I said, the law applies to you good and bad. You don't get to come in here and use the law and argue the law when it benefits you and then tell me it's illegitimate when it doesn't. And he had no answer for that because he knew he was going to sue him. So then, of course, he just lies and backtracks and says, well, no, I wouldn't sue them because you're right. The law doesn't apply. And I said, yeah, and I believe that, right? And so this is the mentality that you're going to deal with. And the big thing for you guys is, right, most of you are trying to recover a debt. And they don't want to pay you. So they're going to throw everything in the kitchen sink at the wall, and they're going to dig deep into the archives of sovereign citizens to try to prevent from having to pay what they owe you or what they owe your client. Okay. And so that kind of takes us to addressing in civil litigation. And Judge Bowles, I think maybe the best thing to do is to go out of order and talk about the Brown v. State case first and how they can use it in those proceedings.
Yeah, probably so. So Brown v. State is a 2018 Georgia appellate case, 346, Georgia appellate 245. And we all keep this in our bench book to reference in the instance that we may need to do.
And I think this is what Mr. Cleveland was there for when I immediately just shut it down. You know, when I first became a judge, I used to have fun with it. And Judge Bowles, as a newer judge, you still have fun where he has fun with it. But I'm too damn busy now to have fun with it. So once they start, I immediately just go, hold on, let me read you this. I think Adam was here for that. Just let me read you this.
All right. So the excerpt that we keep on our bench book and that we'll read is: defendants claiming to be sovereign citizens assert that the government is illegitimate and insist that they are not subject to its jurisdiction. This defense has no conceivable validity in American law. Courts have repeatedly rejected such theories of individual sovereignty, immunity from prosecution, and their ilk, regardless of an individual's claimed status of descent as a sovereign citizen. That person is not beyond the jurisdictions of the court. These theories should be rejected summarily, however they are presented. So what's interesting about that, and oftentimes if you haven't already called them a sovereign citizen, the moment you read that, that's when you'll start hearing the I'm not a sovereign citizen and the disassociation with the sovereign citizen movement, despite pressing exactly what the theories of sovereign citizen movement is. But the key word there, I'll give you an interesting story, a funny story about Judge Lottie, is
I knew we were headed this
focusing on the section of that says individual sovereignty, immunity from prosecution, and their ilk. So Judge Lottie had one that said, I went down that road. I'm not a sovereign citizen. I'm not making those arguments. And it was, sir, I haven't said that you were a sovereign citizen, but the arguments you were presenting, and I think he made a very similar analogy to what he made when he started about the pond and feathers and webbed feet. And, you're telling me you're not a duck, but you certainly look
duckish.
Like you're duckish. Well, you're duck ilk.
Right.
And that's exactly, he said, well, you may not be a sovereign citizen, but you are certainly their ilk. You, sir, are ilk.
Yeah, and he didn't know how to respond to that, mostly because I don't think he knew what, but he did, and and then I told him right there, I don't care what you call it. I don't care if you call it sovereign citizen. It doesn't matter. You fall in that category. You're making those arguments. Everything you filed is denied. And he was like, well, you're not going to let me argue it? I said, no, because this case tells me I don't have to. This case tells me to just summarily reject it. As soon as you file it, to file an order rejecting your motion. And that's what I'm gonna do. Your motion is denied. We're not even gonna talk about it. You can take it to the Court of Appeals. And I have one sovereign citizen who does that. Files something ridiculous, I summarily reject it, don't even let him argue it. He sends it to the Court of Appeals, and the last decision that came down from the Court of Appeals 2 weeks ago, actually, they actually put a footnote on the cover page that says, we would direct the appellant to please refer to this rule, and that if you continue to frivolously file appeals in this court, we will limit your access and deny you access to the Court of Appeals. And that's the second sovereign they've done it to. So the Court of Appeals is fed up with them too. And they're starting to tell them, we're done. You're not going to be able to file any more appeals in the Court of Appeals. And if you do, we're going to reject it because we're not listening to this anymore. This has been decided, right? And so Judge Bowles read that to you because that is your ace in the hole. This is all you need is this brown. And we made a couple copies and we'll leave them up here so you guys can have them, take pictures and get the citations. And we've highlighted the section that Judge Bowles has just read on them. But this is your ace in the hole, especially because obviously most judges are going to be like Judge Bowles, who after I call the civil calendar, I'm going to say, have you had a chance to talk? 99 times out of 100, you're going to say, no, Judge. And I'm going to say, step out the hallway and talk. See if y'all can figure this out. And I will tell the defendant 9 times out of 10, you're going to leave a lot happier if y'all figure it out in the hallway rather than if I figure it out for you, right? And you're going to go out in the hallway and they're immediately going to start with this sovereign ground and how they don't owe the debt because you haven't proven, whatever ridiculous sovereign thing they throw at you that, they're not presumed debt at sea or that, you violated the Maritime Act or that the UCC says this or whatever, that, they didn't contract with whatever company you're representing, they contract with this company and it's illegal under whatever act to sell the debt. This is your ace in the hole. Listen, before we go in there and you get yourself in trouble, I'm going to try to help you. Okay? Let me show you this case. Specifically, let me show you this. I understand you're not a sovereign citizen, but the judge ain't going to care. The judge is going to say you're ilk. All right? I'm trying to help you stay out of jail because if you go in there and start saying this to this judge, you're going to get held in contempt. I'm here to help you. I'm here to work this out with you. I'm here to tell you what my client will accept in a payment plan. Be smart about this. Is it going to work every time? No. Is it going to work the majority of the time? No. But will it work some of the time? Yes. Because I have had sovereign citizens, especially if the ones that you can catch that are kind of the newbies that aren't so confident in what they're saying. And you can tell because they're going to say it to you, but they're going to say it with a look on their face. And forgive me because I'm very blunt, but they're going to have this look on their face like, somebody told me to say this, but I'm not real sure I believe this bullshit either. That's how you know you got to check this, right? And I had a girl in there in criminal court one time, and she was doing this. She was on Zoom, and it was during COVID, and she would say it, and then I'd see her go, and then she'd say something else and go, and this went on for about 5 minutes. Say something. So finally, I said, "Honey, let me tell you something. Whoever you're speaking to is going to get you thrown in jail. Whoever's on the other side of that camera that you keep looking at is giving you very bad advice. And I can tell that you're smart enough not to believe the stupidity that they're telling you to say to me. So here's what we're going to do. This is what the state's going to do. This is the state's offer that they've made. If you want to accept that deal, I'll accept it. You can be done with this today. If you keep going down this path and listening to your mama or your daddy or whoever's telling you to say this nonsense to us, okay, I'm going to hold you in contempt and I'm going to send a sheriff to your house and he'll be there in about 20 minutes. She looked at them and said, I ain't saying that. I'll pay the $100. I said, and I told her, I said, I'm glad to see you're smarter than your parents. and she was like, yeah, but they will. They'll give you that look of like, I Googled this or somebody told me this. I don't know if it'll work, but I'm going to try it. And when you kind of see that hesitation, you know you got a chance. And this Brown case can put you over the top. But listen, I'm trying. It doesn't matter. I'm going home today. But I'm telling you, if you go in and you start going down this path, you're going to lose and you're going to go to jail. Don't go to jail.
You'll find it's pretty easy to distinguish someone who just did a bad Google search the night before and thought that they came across something that was going to be useful to them versus an absolute true believer. And an absolute true believer abandoned ship, abandon all hope. You got nothing. You're not gonna get anywhere with it.
Yep.
You're gonna come into before the judge and you're going to cite Brown and the judge is gonna agree with you and then
Yep.
they're gonna keep running their mouth until eventually they get themselves held into contempt. But the true believers, there's no hope. But the people that you can tell when there's just a Google search the night before and grasping at some straw that could help them out of the situation that they desperately want to be out of. We get it. That's how that works.
Yeah.
But they'll quickly come around when it's that circumstance.
That's right. And this case isn't just your ace in the hole with, the defendant or whoever you're trying to collect money from. This is your ace in the hole with the judge, because they're going to go in and they're going to try to argue all their motions that are ridiculous that they filed in order to try to prevent this.
You can pick them off one by one and try to stoop to that level and do mental gymnastics to try and tell the judge why everything they're saying is ridiculous.
Yep.
Or you can just say this.
Yep. Or you can just stand up and say, Judge, I would just point you to state, Brown v. State, and then read them the highlighted part.
And we would prefer that you do that because
Yep.
we would prefer that you not sit there and try to pick apart each one
Yes,
of their
please.
ludicrous arguments when you could just say this.
Yep. Yeah, and that's all you have to tell us is, Judge, as the court's aware, Brown versus State says that these sovereign type arguments or their ilk are to be rejected summarily, that they have no validity in American jurisprudence. We just ask they can follow Brown v. State, dismiss all this. And then I can tell you what I'm going to do. Agree. All your motions are denied. Next. Right? And then, like Judge Bowles said, at that point, they're going to take off. So, this case is your ace in the hole. We deal with them, but it's also your ace in the hole in court. And I'm going to tell you, I don't expect you, Judge Bowles doesn't expect you. Most judges do not expect you to respond to all the things that they file, right? It would be a waste of your life that you would never get back, because that's another identifying factor of a sovereign citizen is a normal criminal case is going to be about, and I'm not exaggerating, is about this thick in one of your regular manila folders. Okay. And that's going to be everything. That's going to be the pleadings, the motions, the orders, everything about this thing. Okay. A sovereign file is going to be about this thing. And it's going to take two giant accordion files, and it's going to be this, right? And then I have to do an order telling my clerk that they don't have to make copies of the voluminous filings that they do. Okay.
My clerk gets so frustrated with them, especially if we got a couple of them at a time that have really built up the record. They've been riding the calendar and we haven't been able to get their trial done. And the clerk comes up with her cart and she's got 60 files in them that are all about this thick, like Judge Lottie said. And then the bottom level of her cart has 2 files in them that are this thick. And I call the case and she goes,
right. She's got to try to get help to hoist it up to the bench. So that's going to be another very, very quick identifying factor is you will get just inundated with filings. And none of them are going to make any sense. They're all going to be ridiculous. I don't expect you to file a response. If you do, your response can literally be, we object. That's it. Just something to get it on a calendar to where we can bring them in. I can read them the case and say, okay, all that ridiculous stuff that you cited and that you filed, it's all rejected. All of it's denied. Now, you want to go out and talk to this man or this woman in the hallway and see if you can work this out, or do you want me to just give them an order for the whole thing and they can just take it out of your paycheck every month? What do you want to do? If you go out and if you're reasonable and talk to them, they may be able to work something out with the client, get some of the fees knocked off, put you on a payment plan you can afford, or they can just take 25% of your paycheck. What do you want to do? And a lot of times that helps. But, we don't expect you to respond to these filings. I don't know of a single judge that does, because they're nonsense. And for you to respond to nonsense, one sovereign could take up a whole week for you to have to respond to. And nobody expects that. And so my advice is keep this Brown case with you. Have it just throw it in your briefcase or in your laptop bag and leave it, because when you run across them, it gives you a little bit of leverage in dealing with them. But when you can't get anywhere with them, your response, and this will also make the judge extremely happy, is a 2-second thing. Judge, we just asked you to look at Brown v. State specifically, the last 2 paragraphs, and I've highlighted them for you. Here you go. And you can sit back down and I'll say another word and you're going to win 100% of the time.
I was talking with Judge Lottie about this. I kind of used the term, a broken clock can be right twice a day. And even if there is something, for some reason, they just happen to hit on an issue that the judge is like, well, all 10 of these are garbage and cool, Brown v. State applies and I summarily reject them. But maybe this one, maybe tell me a little bit about this one. Well, at least now you've limited your work down to something that, and again, it's going to be an argument that you could probably easily mow through. But you know, if it's not just all right, everything here is garbage. Maybe they did kind of touch on one thing that the judge wants you to expand upon about, and now you've taken what could be an hour and a half of court hearings and turned it into, well, let me just make a response to this, and in 10 minutes you've got what you need. So
right. And I have had one sovereign citizen who I think it was by accident, to be honest, actually did raise a legitimate legal argument. I think he just stumbled upon something and threw it in there, not realizing that it actually applied, but he still filed it. And so we did have to, that I did not reject summarily. But in 6 years and hundreds of sovereigns, that has literally happened one time on one very specific issue. So don't expect to see that much. But by having this case, it can limit what you have to respond to. It can limit what you have to oppose. And it also gives you the room to just say, Judge, we would just ask for judgment on the pleadings. Everything that this person has filed under the Brown case has no validity. Please reject it and enter an order. And 99 times out of 100, we're going to go, sounds good. Thank you for being here. Y'all have a good day. And I mean, look, at the end of the day, we don't take pleasure in putting anybody in jail. But we're only going to put up with so much at the same time. And so once you get what you want, you're done. Know when to stop talking, sit down and be done. And when you do that, they're going to talk themselves into jail 100% of the time. I even told one guy, I don't even remember what the ticket was, but I remember I had never put anyone in jail on this ticket. It was so minor. And I told him, I said, you are the first person to literally talk themselves into jail on a ticket that I would never give anybody 1 minute of jail time. I've never seen it. Like, you were just not going to be happy until I put you in jail. And a lot of times they're not, because they want to make these TikTok videos. They want to put this out there about how they're oppressed by the system, right? And they're not. They're just idiots. And they buy into these things. And I say idiots loosely, meaning some people are intelligent and they're choosing to believe this nonsense. Those are the ones I refer to as idiots. Most of them, however, have some type of mental health disorder, and they're being preyed upon in order to sell books, in order to sell classes. And those are the type of people who will buy into this without even understanding what they're buying into. One of them showed up one time with me, and he had this random, like, 80-year-old white guy with him dressed like a cowboy. And he tried to come up to the bar, and I said, no, who are you? He said, I'm the ADA representative. I said, you're the ADA representative? And he said, yeah. I said, what organization is that? And he said, the Americans with Disabilities Act. I said, did you hear the last word there? That's legislation. That's not an organization. There is no representative. No, get in the back. But he was using him as a puppet. And this man kept going to jail because he kept listening to this guy over and over and over again. I mean, the guy ended up spending like 1.5 years in jail because this guy couldn't feed him. I mean, he had this huge 3-ring binder that he would take, and he'd be showing him, read this. And I'm like, don't read that. That's going to get you back in jail. And how many times we got to do the same dance before we stop? But that's what you're dealing with. Know what you're up against. Understand this too. They are dangerous. Some of them are extremely dangerous. If you feel like in talking with them in the hallway, no judge wants you to be unsafe, me included, me especially. So if I send you out, if you're in my courtroom and I send you out to talk to them, if they start getting aggressive or making threats of violence, stop the conversation, go back into the courtroom and let the judge know what's going on. I've had them show up at my house, right? I had to have a deputy stationed at my house for 10 days, 24 hours a day, because one showed up at my house and I wasn't driving my car at the time. My wife had just taken it, and he obviously didn't know that and went running after my car on my street. So for the past 3 days, I've been building a gate and privacy fence across my driveway. And so understand that while we laugh and we have a good time, and to us it's ridiculous because we went to law school and we understand the law, to them it is cult-like, and that they do present potentially a very violent threat. And so be aware of that in your dealings with them as well. And if it gets to the point where you feel like that, stop the negotiation, stop the tactic, and remember, you've always got Brown. Just go in and get your judgment and don't put yourself at risk. And so I would also, as I'm seeing more and more sovereigns becoming involved in the civil world, I would tell you, be careful about your online presence. Make sure your address isn't online. Try to scrub it. See if your local county tax commissioner, they do it for us as judges, but ask if they would be willing to let you have your address removed from public record from tax records because of what you do and the people you deal with. If not, there's always a company called Delete Me, and it's a company that a lot of counties pay for their services for the judges, and I'm trying to get Henry County to do it for us, especially since I've had people show up at my house, which, for me, I'm not so worried about because I own a small arsenal. However, there are some older judges in the county that I would be worried about somebody showing up, right? And so this Delete Me company, my understanding is a bunch of ex-CIA guys who started this company as a way to make a bunch of money, and they will erase you from the internet. I don't know how they do it, but they are very effective at it. So consider that as well. But while we do get good laughs out of it, and it's one of the few things in our job where we get to laugh a little bit, also understand some of them are dangerous, and be on the lookout for that as well. I know we're right up against time here, but
Questions, comments, humorous stories?
yes.
Have you all run across or heard about sovereign citizens represented by counsel who take up their argument?
Okay, so you're gonna laugh at this. One time in 6 years, I had a guy that was a sovereign citizen that came in, and he was represented by his sovereign sister, who was the lawyer. Now, she's a bar lawyer in the state of Georgia, which how you went to law school and think that I couldn't reconcile it. She never presented any sovereign type arguments to the court, but the prosecutor in my courtroom told me she was making them to her constantly. So I guess she knew better than to present them to the court. But as far as in general, no. And in fact, in criminal proceedings, when I have appointed elbow counsel, I've done it over their objection because they do not want to wait. And I do it to take away, any type of appeal that their rights were violated because they didn't have a lawyer. So most times what Judge Bowles and I do and what most judges will do is say, I'm going to appoint counsel, and they will immediately get pissed off and start arguing. I don't want a lawyer. I'm doing it myself. This lawyer doesn't understand.
Right to represent myself.
Yep, you do have the right to represent yourself, and we're going to let you. But they're going to be sitting behind you in case you need questions. And I tell the lawyer, I don't expect you to sit at the table. I expect you to sit behind them and be available if they have questions.
I actually had a defendant that was charged with a stop sign violation, because it's always something that he was a disbarred attorney. I guess the analogy I would use is cheese slid off the cracker, and he he went full sovereign, and it was an ordeal. I actually inherited him from the judge whose seat I was appointed to. And he'd been riding the cow. He was one of those that the clerk would break the file up and slam it on the table, and the table would be a little shorter. I've dealt with that with a disbarred attorney, but never someone who was still holding a bar.
Most of them do not want lawyers, and they will really, really, really fight us on appointing one. Correct.
Yeah.
Correct. They're part of the corrupt system, and that was the argument that they make on appeal, is that they were forced to have a lawyer. And I'm like, well, I don't think that's a violation of your rights. I know you had a question.
Yeah. Thank you. You all dealt with any instances where, a litigant is trying to, and I don't want to use the word dox you, but dox almost your financial records or your credit and that sort of thing. We had a situation where they tried to do it to judge, the clerk, and my client, where they're trying to file fake UCCs, and that sort of thing. I mean, have y'all ever had to refer to the DA or anything like that?
I have not, but now I have something else to be worried about. Thank you.
I've not run across that issue either. It doesn't surprise me at all. But But I think that's the exact thing to do, is to refer it to the district attorney's office. I mean, obviously they're committing felonies. And that person right there is a prime example of somebody that you should be fearful of, that you need to be prepared, to deal with. And look, in our line of work, regardless of your feeling on firearms, I'm a big proponent of become proficient with them, get a carry permit, carry them where you're legally allowed to, because they are in your community. You never know when you're going to run into somebody that you've dealt with that's a sovereign, and be prepared to protect yourself. But the person that's willing to go to those lengths is one that you should worry about. I probably wouldn't try to negotiate with that person without other people present, or at least close by. I would probably try to keep it confined to the courtroom. But I think that is really the only way to handle it. Obviously, they can be held in contempt for it, but you have to do an indirect contempt and do it. So I think the easier thing to do is just hopefully let the DA bring the charges, let them get prosecuted for it, and then just let them go sit in prison for a few years and get out of everybody's hair. Now, on the downside for you guys is they're not going to have anything for you to collect if they're in jail. But I mean, I guess you could take 25% of their little prison paycheck for the little work that they do there, because they do get paid. Actually, I was funny enough, a guy was drugged up and broke into my car. Of all the cars in the parking lot, he picked mine. And so I'm still getting restitution checks from the Department of Corrections. So they do have a check that you can go after even if they're in prison.
They have gold, probably.
I'm sorry?
They have gold.
Yeah, that's right.
Dollars.
Yeah, make you an extra license plate. I don't know. But yeah, there are options even if they're incarcerated to try to collect. So anything else? Well, thank you guys for having us. We enjoyed it. And I will leave this case.
Thank you.
So that you guys can
We'll put it from the back table.
disseminate it.
Thank you all judges for being here. Thank you. And we're gonna go a 5-minute break, and we'll be back for next segment at 1:50.
5 years. 5 years.
Good? Yeah, great.
All right. Welcome back, everyone. Our final presenter today is Benjamin Rachelson. Benjamin is a partner at Adams and Reese, and he practices in the areas of construction litigation as well as commercial collections. And in particular, he represents secured creditors in enforcement actions. When we're lucky enough that we have some collateral that we can go after, that's good news, but it can be a little complicated and tricky. And Benjamin's going to talk to us today about how we go about enforcing our security agreements. He's going to talk about some replevant actions, other personal property and real property foreclosure actions, as well as a little bit on getting a deficiency judgment in the event that our collateral that we seize isn't valuable enough to satisfy the total debt. And with that, I'll leave it to Benjamin.
Thank you, Jake. Afternoon, everybody. That was very interesting on our topic. Very enlightening. I've actually dealt with that quite a bit, and hopefully be able to use the Brown case. I wish the judge had known about that previously. So we've got our outline that y'all got the materials on, and we will start with the secured agreements and security agreements, and exactly what we need to do to protect our collateral and obtain deficiency judgments, and a little bit about the real property foreclosure and the confirmation process as well. As we know, we're essentially dealing with UCC in Article 9 and what we need to do in order to protect, secure, and obtain the collateral, if necessary, obtain a deficiency judgment. So, and I think the most important thing that a lot of people don't realize and understand related to that is the attachment and perfection of the security interest and how that occurs with respect to the debtor. And what we are generally dealing with is once the security agreement, or most people just view it as a contract, is executed, that is perfected vis-a-vis the secured party and the debtor. And from that nature and that perspective, you have the right to go and pursue an action to collect upon it. But oftentimes what we have to deal with is another secured party. And so what we are dealing with then is the enforceability and the perfection actions and how we then proceed. And what we first look at is Article 9, Section 203 of the UCC related to what we need to do in the three elements in order to perfect our secured collateral. First, obviously, we talked about value. That's generally the basic understanding about what the transaction is. And I deal a lot in the construction industry, and you certainly see that related to vis-a-vis exchange of equipment, financing, anything of that nature that you will see. And a lot of times what we also deal with, and what you have seen, is some creditors try to put these security agreements into a credit application. And that certainly has raised some questions as to the enforceability of a credit app and whether that would extend to the ability to recover equipment on default. There is not much case law out there related to that. We certainly have dealt with it quite a bit. To the extent you can certainly attempt to do it, we would recommend it. The next issue that you've got to deal with under Section 203B is the rights in that collateral and how to, what meets the conditions that are met. So you've got your general elements of your security agreement, the description of the collateral, who's got possession, and what are you securing. So those are the three elements that we generally always look for in terms of how, what, who, where, and why in terms of enforcing your security agreement and the actions that you then want to proceed under. Next issue that we also address is perfection. Like I said, I can't tell you how many times I get a phone call from a client that, do I have rights to go after collateral? And the issue always addresses, was the agreement signed? And that is the first issue in the analysis that we generally always deal with in terms of who signed it and who is enforceable against. What we will also address then is the financing statement and reporting under the UCC. And what in Georgia, all you have to do is record it in one county, and it's enforceable as to all across the state of Georgia. The issue that you also sometimes deal with is whether and how, what about when the equipment across the state line? Certainly that's a consideration that you would want to deal with your clients in terms of, most of my clients in general, they cross state lines, they work in all of the Southeast. So the question is, can I perfect it? How do I collect in certain other states? And what I always recommend is you record it in any state that you're working. And you also got the automatic perfection, and that's purchase money security interest. That's harkening back to our law school days, I'm sure. We can certainly think about how that action perfects, and that's generally with the vehicle. So you've got your PSMI, and you perfect your rights and your interest in that when you loan money to secure your assets. So the first, your practical points as we outlined are the authentication. A consideration that you always want to address with your clients is who is signing the security agreement. I can't tell you how many times I deal with clients where they have an office manager or somebody who lacks the authority signs the credit application or security agreement, and the question is then, so it is a very, very key point in consideration as to who has the authority to execute security. And then generally the description of the collateral is not too much of an issue, but you certainly want to make sure that clients understand what they're identifying. And I have seen numerous cases where if you've got a VIN number that identifies the vehicle, that's mistyped by several numbers or even one digit, you're going to have an issue. And anybody who defaults under security agreement will certainly use whatever they can to avoid having repercussions and liability on that debt. And the last issue is the issue related to proceeds and how you collect upon it and what is covered under that security agreement. Again, like I was mentioning, related to the issue of the attachment and what is covered under a credit application. Oftentimes you've got bank accounts, assets, and the like that are certainly covered, and you've got to make an understanding and let your clients know how that would attach and what you can collect upon. Real tricky issue that obviously we're generally have to kind of dance around is what happens after default. And what type of collateral you're dealing with and how you want to collect and cover a monetary judgment for your client. First issue you've got is, are you dealing with a personal property, or what is it that you're trying to collect upon your right upon default? I would always recommend, and we've dealt with this quite a bit in terms of waiver, what you could put in your security agreement in terms of what can and cannot be waived under the UCC. Under 11.9.609 are the rights that are governed under default and what our options are to recover. Question is, do you want to take possession of the collateral? Is the equipment usable? Do you have a right to inspect it? What can you do to ensure that you can essentially collect the most amount of money for your client? And the two options are a judicial process, or you can certainly attempt to repossess it, but I'm sure we've dealt all with issues related to breaching the peace. And the wrongful repossession issues that you potentially will deal with. Under the judicial process, we've got the OCJ 4414-231. And that's the short form procedure under Georgia law that not many attorneys utilize in order to file a replevin action to get the collateral back. And I've often gotten many discussions and questions with clients about, can they combine a breach action together with that? And the issue is, you certainly can, but you're not going to expedite the proceeding. And if you file a formal complaint, then you have your discovery process, and it is a much more extended process. So my recommendation is always to first file your action to recover your collateral under 4414-231. And then once the collateral is recovered, sell it. We will certainly discuss those procedures related to the deficiency action from there. And then you can file your breach action or your deficiency action. And we also need to, there are certain considerations related to the statute of limitations time and how long you have to recover that as well. But the first issue is, should I or should I not proceed under 4414-231? And that is a short form proceeding in most states, or excuse me, most counties would hopefully file what the statute provides, but you'd be surprised, especially in DeKalb, where they have their own unique form. Vary quite a bit. We take what we're given, so that's the best thing we can do. And under that proceeding, what you do is most of y'all know, I'm sure, what you do is you file your affidavit. You serve it upon debtor or the party in possession of the collateral. And that's very important because a lot of times your secured collateral has been transferred to other parties. And the statute is explicit that even if somebody is hiding the collateral and they're not a party who executed the security agreement, you have a right to repossess from them. And under that proceeding, then you've got OCJ 4414-232 and the issues that you deal with upon service of your request. And parties most of the times, or all of the time, they have 7 days within which to file an answer. And the issue that you generally then deal with upon that is how quickly you can get a hearing before the court. And most courts, they dilly-dally around and they're not going to rest your issue. But what happens and what you can assert, and under the statute, it's very important to do, is you've got a right to be placed on the next calendar, next available non-jury trial calendar. And that, if you send a notice to the judge's staff attorney, you usually get their attention, and that should get you placed on a calendar as soon as possible. That will then allow you to, hopefully, if you're quick and you're good, you can get an order within probably 60 days. But obviously, it depends on the county, it depends on the judge. Fulton, maybe Henry with these folks. It obviously depends a little bit different. But once you have your hearing, there are certain considerations that you probably should understand and will help you, give you an advantage as to how you can collect and if there's a dispute as to the right to possession. And many attorneys don't utilize this, but under 4414-237, there's an automatic right to post a bond if possession is disputed. And that is a very, very crucial component to the foreclosure of personal property proceeding, because I'm sure all of us in this room are aware of parties who we deal with, the defendants. They oftentimes do not have enough backing and financial backing to post a bond. And if they are unable to post a bond, you have an automatic right to possession. And that doesn't come up too often, but if it does, and your party is asserting their right to possession, the judge has to give you an automatic right. Very, very, very helpful in the event of one of these sovereign citizens potentially coming up to cause some issues. So the question then is, once you get the collateral back, what do you do? This also is a very, entangled procedure, and what clients oftentimes they can't understand exactly how to deal with it in a consumer versus non-consumer transaction. So the question is, and then we go back to what the security agreement provides, and we have an automatic right to identify whether there will be a public or private disposition. This is upon your repossession. You've got 10 days to send the notice in a consumer good transaction, 10 days to send a notice to your debtor of your intention to seek a deficiency. And what is also unique, and when you're dealing with motor vehicles, and I deal with quite a bit of secured lenders and vehicles, is that the requirement as well to serve a notice under 10-136. And the statute does not explicitly provide that your notice under 11-9-611 and 10-136 are coexist with each other. So what I've done and what I recommend to my clients to do is to serve a notice that combines the language of the two. And it is you certainly can send both notices, but I recommend you combine the language as the statutory form in 611 that allows you to serve a notice upon the debtor at the address identified on the security agreement. That's crucial that it must go to the address on the agreement unless there's a notice provision in your agreement as well. So those are also considerations that when you assist your clients on the front end with drafting the security agreement, number one, where's the notice go? Number two, do you have a public or private sale? Number three, what are the considerations? What can we waive and can we not waive in our security agreement? And all these procedures are certainly governed under 11-9-611. The issues that are always at issue is, have they received the notice? And then we go back to our procedures under Georgia law in certified mail, Federal Express, regular mail. I don't recommend regular mail to anybody these days, but certified mail certainly works. The question then is, when does notice effective? Under Georgia law, notice is always generally effective upon the mailing. That's very crucial as well, because most clients, at least some of mine, do not keep their green cards. Or the green card is kind of an ancient term, but the labels. They don't keep the labels. And that is important because every single issue is at play when you attempt to seek your deficiency judgment. And also important, and kind of skipping around a little bit related to the deficiency judgment, but a judge has an automatic right sua sponte to raise that at any time. I've had this happen to me before, where the defendant does not even bring that issue up, and the judge, most of these are pro se defendants, but they will certainly bring it up, and if you do not have the evidence to support it, to show that you sent the notice, to show that you comply with 10-136, they'll kick it out of court. And the law is that if you do not satisfy these elements, then your obligation is the debt is essentially waived. Question then is, how do you apply your proceeds, and what happens once you get the vehicle back? So first off, you have to serve your writ, which is another issue that certainly takes quite a bit. Very difficult with your considerations. So the question is, what do you do once you get the piece of paper? Similar to, I'm sure you've talked about earlier today in terms of how do you collect upon a judgment? How do you collect upon a writ of possession? What do you do? in most, it depends on the county, but most states and counties, they require you to coordinate with your recovery agent and the sheriff to serve the writ. And at that time, the sheriff will then have the right to recover possession of the collateral upon, usually with your recovery agent. Now this, I'm talking mainly about vehicles, and if you're dealing with other types of secured collateral, I've got some medical equipment as well. Many law enforcement officers are very leery in terms of trying to go collect upon collateral that is not identified or not secure. So what you would hopefully do is run a UCC search as well prior to that. Make sure that your officer is certainly aware that there is no other secured party that has a right to collect upon. At that point, then you serve your notice about what you're going to do in terms of your disposition. Question then we also discuss is the consumer versus non-consumer transaction and what notices you need to provide in those situations. And there are certain qualifications about what is and what is not a consumer transaction, and under OCGA 613, 11.9, 613, and 614, statute identifies what is not consumer transaction. Oftentimes, I certainly try to bend the rules and say most of my transactions are non-consumer because you get a little more leeway, but that's often not the case. So the issue that you then address is what do you need to provide in your notice? The statute does a decent job of identifying a statutory form, but getting your clients to utilize that form is also quite an issue sometimes. But my recommendation is you attempt to draft a form for your clients and hopefully continue to use it. Whether they actually send it out is another thing, but we do the best we can. So the next issue that we deal with is strict compliance in terms of what happens if you do not comply. So, and whether a secured party can accept a partial satisfaction. And also the dispute related to the valuation of the collateral. So once the collateral has been recovered and then you try to sell the collateral, steps that I generally advise my clients to proceed with is you get an auction company and they review the collateral pricing. Much documentation as you can get in order to identify how much that collateral is worth, what procedures you utilize to show that the sale was commercially reasonable. Because if you can show, and the law states this, a commercially reasonable manner, time, and place, those are the three factors that a court looks at and make sure that your collateral is sold in a proper manner. So for instance, I've got a wood chipper that I'm dealing with for a client right now. And the steps that they had to take in the auction, you'd be surprised. I think there's 11 or 12 remarketers that go out there to cover a wood chipper. And we identified 3 different remarketers, and they all came out and inspected the collateral. And then we had the collateral sold, listed at auction, these online auctions. And we still received a vigorous challenge from the defendant's counsel related to the valuation. Of course, they didn't provide any of the documentation because all they have to do is, pierce one hole in your legal argument that it's not commercially reasonable and you're done. So that is why you make sure you monitor each step related to the recovery of that collateral and what you need to do to ensure that you get as much for deficiency as possible. Once the vehicle or collateral is sold, then you still have another statutory right in terms of what is next related to the notification to the debtor. All of these issues are what I would generally recommend my clients do, and what I try to do is to put a statutory checklist together in terms of what needs to be done in the time frame that needs to be done. But what you often deal with is you've got credit managers who don't have enough time to deal with it, and they frankly don't. They think they're doing it right, and they work over multiple states, and they don't know which state's laws govern. And so that's the issue that you've got to address in terms of which states you're going to address and who you're gonna provide the notices to. If you get a surplus, you probably are the only creditor that I've ever seen get a surplus. There are certain obligations in terms of how you would have to repay the money to the debtor. But if you do that, then I'll retire today. It's a very, very, very rare option. As you know. But under the UCC, under 119615, and that's the calculation requirement in terms of what needs to be notified and what the debtor should be advised of in terms of the deficiency. And going into that, you've got every single financial information and what your client also needs to be advised of in terms of your marketing costs, how much it costs to move the collateral to a certain facility in order to get sold, what other, even the legal fees, and that also goes into your security agreement as well, in terms of how much and what you will be entitled to on the sale of the collateral. And once that notice is then sold, then sent, then you have to pursue your deficiency action. And under Georgia law, you've got 2 years from the date of repossession to finish this process. That might seem like a while, but I would be remiss to probably provide that. I think most of my clients have sent you these 5 to 10 days before your statute of limitations deadline. Please file it. And what I've also dealt with is the statute of limitations does not hold if you file that action within a week or so prior to your deadline. And if you do not show reasonable diligence in order to serve that lawsuit for a deficiency, you are going to lose your right to recover the deficiency. I've had one fairly recently. I had an issue that was brought up, and there was service issues around COVID, and it probably took us over 6 weeks, over 6 months to serve the debtor, more because my client forgot about it, and we lost on summary judgment related to that exact issue. So that is a very real issue that every single debtors council will take note of in order to poke holes in your right to recover the deficiency. So regarding the documentation and checklist in terms of what you need to do, it's very thorough, and I'm sure you picked it all up. We've got number one, you've got the security agreement, the execution of that. In terms of what you can advise your client, how they need to entertain and understand the requirements under Georgia law under the UCC. What I would also advise them, most importantly, is what they can do in order to waive their right to certain issues under the UCC that they do not have to comply. Because the less they have to comply with, the better, and the more likely you are to recover your deficiency. Obviously, certainly, you've got to be careful of whether this is a consumer transaction and what type of debtor you're dealing with. I was certainly dealing with, recently there was a tractor that was driven over the road, and you would be surprised, I think there's a statute in Georgia that provides if a vehicle has the ability to be driven on a highway, that's a consumer good, even though this was used completely as a farm good. So at least that was the argument from debtors council, whether that actually held water, but those are certain issues that you've got to address. Questions about the security agreement process? Okay, yes, sir.
With the boom in private credit, how are you seeing this ongoing issue of where just the CSC Corporate Solutions, CT Corp, you file it now, Lien Services or whatever it's called, put their name as quote the secured creditor as opposed to the real creditor. Our brethren on the other side of the table on the bankruptcy side complain nonstop about it, and it seems like it's kind of misleading as to who you're doing business with if you're not revealing who that creditor is of record, and making it very difficult to figure it out. I was just curious, like what you're seeing and how you would be advising a client to deal with that situation.
Well, that's why I identified, we always go back to the actual document, what's on the document in terms of note. Because I think what you're referring to is UCC that's filed, correct?
That's right.
So if you're utilizing that, you're not using that document in order to repossess or perfect your collateral, but to obtain the collateral. If I would be very shocked if somebody put a CT Corp address on the security agreement itself. I think that if they utilize a lien filing service, that's separate, distinct. Hopefully, the document itself has what you need on it to collect on.
So you think it's so long as it says the name of the borrower,
Correct.
and identifies with specificity of the collateral, and it might have some boilerplate language or what's the term of art, super generic terms.
Yeah.
You think that would be sufficient?
Well, that's on the UCC itself, but again, that's what a lot of people, the distinction that they do not remember is the document itself that you execute is the actual document that, in my mind, perfects your security, your interest.
Sure.
So that document itself is the one that needs to govern, who you have the right to repossess from. Now, when the issue that you're dealing with, the UCC, and I mean, how many times do you have that come up that you've got multiple parties competing against that interest? So then the question is, are you fighting over who's got the right to repossess and who can collect on that? My understanding and my recommendation would always go back to the document itself. And if CT Corp or CSC or lien filers putting their name on there, they've got to have some other legal obligation or notice service that they forward on to the creditor, but that's a separate agreement. Anything else?
Yeah. Could you, I'll open it up for other folks too. Most of what I do is commercial. Can you touched on some of the differences between consumer and non-consumer collections. Can you maybe explain in a little more detail what the analysis is and what the courts are looking at in terms of distinguishing?
Sure. I think I went a little too fast.
Well, for me, I'm slow. I'm slow.
Yeah. So, what they're looking for obviously is the distinction. Look, you've got your statutory form that they're looking at in terms of not necessarily the court. It's really what the compliance with the notice provisions and how you identify time, the most important thing. And what you identify in terms of the dates and when and what your procedures are. Because notices are not that different, okay? But what you've got to ensure, I've certainly dealt with this, and people will attempt to, harp upon every single sentence in that notice in terms of whether you're compliant in order to obtain a deficiency. So utilize the statutory notice under 613 and 614. That is the most important thing. And if you comply with that verbatim, in my opinion, you satisfy that as a matter of law. But what courts are then looking at in terms of the issues is, what did you do to ensure that a reasonable purchaser or a reasonable party would consider this sale proper? For instance, I've got a client who sold, repossessed, they floor planned a dealership, okay? And the issue was you attempted to depress the sale because you wanted to get as much money as quickly as possible. So what you then have to show you've got a reputable entity that inspects and takes this collateral and advertises it properly, and there's proper communications between client and the entity that's selling the collateral to make sure that valuation is proper. Okay, so that's what courts are essentially looking at from a non-consumer transaction. The consumer transaction is very tricky in terms of how the intertwining of 10136 and 613 are, because I've had many clients, not excuse me, many debtors counsel will certainly advise you that you need to send a separate notice as to both. But and that's generally dealing with the commercial consumer view. But from the non-consumer transaction side, it is the dotting your I's and crossing your T's related to how the collateral is repossessed, what you do upon the repossession, and then what efforts you have taken to remarket and sell it properly. Also, how is your accounting? Okay, that's a very crucial issue as well, because I'm sure many of you have clients whose accounting software or whatever they give you some spreadsheet that looks like Japanese to you, and you try to attach it to an affidavit as a business record, and judges will kick it back and say, I have no idea how to authenticate this debt. And so those are issues that I certainly see quite a bit coming up with a non-consumer transaction. So the questions would be, it's not necessarily what's coming from an attorney, it's what do you need to show the judge? In that situation, they want to see kind of your steps, and what I generally do from my perspective. A lot of these turn into defaults, like you know well. So what you have is you provide a business records affidavit that shows, this is what I did on this date. Some courts, maybe our friends from Henry County, will just let it go through, but other judges are very strict about it. They want to see everything you've done. I had a judge up in Floyd County in Rome, and it was unopposed, and he wanted to see every single piece of documentation that my client did in order to sell the collateral. There was some, truck from finance from Hyundai or something, but it's really an internal process that you kind of need to guide your clients about in terms of what is necessary to show compliance with the repossession process. And that also helps from an internal controls process as well. Because if they do it right, then hopefully it's streamlined. Get your judgment, then we have to collect. That's the issue. Anything else?
Sure,
Yeah.
sure. I'm going to pepper you.
Go ahead.
So, and you touched on this, and you've all probably dealt with this in some form or fashion, but what's your best strategy or your thoughts on dealing with the debtor who has, whether through fraud or some sort of scheme, has multiple conveyances and security interests on the same collateral, and you find out or you learn that there's an action being taken against your collateral, maybe you think it's by someone who is subordinate or a lower priority than your client's security interest. What's your strategy for addressing that, stopping that process so someone else doesn't foreclose on your collateral?
Well, that's a very interesting. So I'm actually dealing with it quite a bit. That in the consumer goods transaction, that happens very often. And what we're seeing is title washing for many motor vehicles. And one of my clients, I don't know if somebody in this room can figure out how it's done, you'd be a millionaire, but you've got a vehicle that's financed through some motor vehicle security, a financier, the ABC finance company. And the fraudster who financed the vehicle somehow go to the DMV and wash your title. However, it was never satisfied. And then a second security interest is created with the new finance. So the question I believe you're asking is, how do you deal with the repossession efforts for that? And I had a case that didn't go my way, but so the issue is, it's the entrustment doctrine of the UCC. And what I have learned since this case happened is you can never perfect good title through theft or fraud or forgery. And so the question is, do you want to repossess that being the collateral, or do you want to go after the party who participated in the fraud. And what we have been doing, and what my client has been doing, has been suing the dealership who's last sold the vehicle rather than repossessing the vehicle itself, because that party is better suited and in a better position to get, be made whole. And because they have a title bond, are able to reimburse you. Technically, you have the right to recover that collateral because you cannot establish a BFP regardless of how far down the chain of title that is. And unfortunately, my client was on the wrong end of that, and we lost a deck action with it. So what we generally do and what clients do, if you've got a competing interest, is you file a deck action. And then court would hopefully determine as to who has the right to recovery of that. And the second issue you've got to deal with is unwinding that second security there in and of itself. So, but that is certainly a consideration that's happening all over right now. So keep going.
All right, okay.
Keep going.
I'll answer
Yeah.
your questions. All right, I think you said, and remind me, what was the time frame for seeking your deficiency judgment after you?
2 years from the date of repossession.
If you've missed that 2-year period, hypothetical, would you still have an ability to pursue a judgment on the underlying obligation and then seize the collateral through normal post-judgment levy process? Now, that's obviously not as good as foreclosing under your UCC or security agreement. Would that give a creditor some sort of backup option if
Do
they
you
just
still have the collateral or?
Yeah, do you have, where's the corrupt?
I'm assuming that you don't have the collateral.
Correct. So the answer in that situation is you've got 6 years to file a breach action on it. But I mean, there's case law out there that addresses this exact issue, and I'm sure you've seen it.
Well, and I guess where I'm going at, this comes up, I guess, more in real property scenario than personal property, but I've had cases with usually large equipment that's difficult to seize.
Sure.
It's like industrial equipment. And there's a question as to whether you just try to repossess it, knowing that it's physically difficult to do so, or you just go ahead and get your judgment. You buy a longer period of time to dispose of and seize and deal with the property, because now you have a judgment, you have a 7-year period to levy versus I'm running out trying to seize it, and then I have a 2-year period to try to get it sold and get a deficiency. And so I don't know if that's, you have any thoughts on that? Or
yes, I've seen this come up. So the issue is, have you exercised control over that property? If you have possession of the property or some sort of control, then, in my opinion, the deficiency clock begins to run. So if you're going to proceed in that manner, essentially you're letting the debtor keep the collateral, and you can't repossess it and then.
I've only ever considered it where the collateral is extremely difficult to move. It's not like a
wood chip.
Like, well, it might. I'll tell you the case. I mean, it worked out well. It was a successful case for me, but it was about 30 tons of industrial wire. So it wasn't.
Well,
but I wasn't sure if that was something that's come across, or if that's a strategic question on the front end of some of your cases that you have to talk through or consider.
Most of the time not, but because most of the time they will hopefully get the collateral back. But it certainly has come up, and I had a client who they had the vehicle and they picked it up and then they returned it for this exact issue. And they said, we didn't want to start the clock for us to have to sell it, so they gave it back. And then I was kind of at a loss as to when to start the analysis, but it was certainly an interesting issue because their general counsel said, give the car back. We're not ready to, we can't sell these right now. So that certainly come up. But obviously you're giving them the benefit of keeping the collateral. And then the question would be, well, what if they want to voluntarily surrender it?
To be fair, in my this is a very weird, unusual scenario. As part of my lawsuit, there was an injunction. So
you couldn't pick it up.
they couldn't,
Yeah,
they
oh,
couldn't dispose.
they
of
couldn't dispose of. it.
Correct. So there was some protection built in, so I wasn't worried about it getting sold on.
Well,
It's an unusual scenario, I admit, but I'm just
you're
trying.
trying to trick.
I am trying. to- It's like law school.
No, I mean, no, I mean, if there's an injunction where, so I suppose at that point, it would, the clock wouldn't begin running.
I'm basically asking you a question I already know the answer. to.
Well,
But
and
I'm
I
just
mean,
curious if it's a strategy that you see coming up more frequently.
well, you obviously, in Georgia, it's one of the few states that gives you the right to proceed with both actions at the same time.
Yeah.
So I certainly, recommend doing that as well, but then that goes back to the discussion related to, the affidavit for repossession and whether that's a sufficient way to do. So, you certainly can do it if there's an injunction in place. I suppose I probably wouldn't. I think you knew the answer, but are you, I would do the same thing you did, but I think that it's certainly.
It's just helpful information.
Yeah, very helpful, yeah, very helpful. Anything else? Yeah, question?
Yeah.
Question?
No, I'm good. I was just making sure I know you have more to cover.
Oh, I do,
Yeah.
yeah.
Oh, okay. I'm sorry.
That was my look, sorry.
Oh, no, we've got the real property deficiency action, the confirmation action.
Yeah, thanks.
Yeah, of course. All right, so moving on from the security interests and talking about the non-judicial foreclosure process in Georgia. Obviously, we know Georgia's a non-judicial foreclosure state, which gives us the right to advertise and sell properties, at the courthouse steps without having to get a court order. Question that we all generally deal with from there is how to obtain the deficiency judgment and what needs to be done. So the confirmation proceeding is a very tricky and kind of confusing statute and issue that we certainly address. And before we even go there, I believe, and I was doing some research last night, there has been a proposed legislative amendment, but then that was enacted this year, it's not enacted yet. That's going to revise the notice of foreclosure sale process and the definition of a debtor. So the statute would be amended from OCJ 4414, 161, and 162. So there would now be a 0.2.1 to define the debtor and what the notice of foreclosure sale. So obviously that is prime CLE material to keep our eyes out on what we need on what's going to happen. I suspect it's probably going to be amended and it be enacted here shortly. But go ahead.
I was going to ask, does that put the guarantor back in play if there's waiver language in the agreements?
In terms of the mortgage?
Like the guarantor with the ability to waive confirmation?
Correct.
As the
Yes.
amended statute?
Oh,
Guarantor back
there's-
in play?
In terms of the definition of a debtor, so that's a good question. I haven't actually determined that yet, so I don't know the answer. But we will see in terms of what is enacted, what is not. But back to what the foreclosure sale process is and the confirmation process. Within 30 days of the sale, the confirmation process must be initiated. And most of us, I don't know, dealt with it, but I don't know if you still have to do it, but what I used to do was you had to walk your sale down to the courthouse to the judge and get the date and time stamp as to when the sale occurred and have a hearing set. And then service was confirmed upon your debtor related to the deficiency.
Just 1 second. For the folks who have done a foreclosure or at least somewhat familiar but haven't ever done a confirmation, can you describe what it is you are walking to the judge?
Yeah, you're walking your deed under power and you're walking and you go down to the judge. Essentially, it's in essence like a rule nisi for a hearing. Okay, and what you've got is your date and time stamp that the judge will review and set your hearing related to your initial action that you foreclosure action. So it's essentially what you usually use is your form related to rule nisi, and the judge will then review what occurred and then you have to serve that upon the debtor. And that has to be personally served upon your guarantor in order to obtain the deficiency. So that's probably the most crucial part of this whole process. And it certainly is, for most people, they don't usually have to go down. I recall back in the day going and sitting outside the judge's chambers in a chair, just waiting for the judge to come out and say, all right, you can come back in. That was some of the hazing that I used to have to do a long time ago. But it certainly was, it's a good process and also helps you understand how these, the inner workings of the, I guess, a presiding judge work. You have the option of going to, once you file your action, you get an assigned judge. And I'm more thinking about Fulton County. But if that judge who's been, your matter's been assigned to is not available, you can go to the presiding judge as well in order to get to show him your documents, him or her, your documents related to foreclosure sale. And what occurs next is then obviously you've got the served with evidence, which is an issue in itself if they've been foreclosed upon, or most of these are commercial entities and they probably have some registered agent. And the issue then is the evaluation and the competing amounts that you have to establish at trial. And generally, what you should have prior to your hearing is an appraisal of the property. And that will then establish what the true market value of the property is. So kind of similar to what we're dealing with the foreclosure of personal property, but what you then have to establish is how much the property sold for and why, and it's just the basis for the deficiency action. Kind of a side note, my client in our firm just sold 2 properties at foreclosure on a courthouse steps and received excess in the amount of the sale. So who knows what, maybe something's changing these days, who knows? So they're practical considerations. So what happens then is you'll have a trial, usually like your normal judicial trial related to valuation. You get your witness to be established, the appraiser would come down and you follow your normal procedures and related to authenticating the amounts that are owed, how you would then establish debt. And the reported sale price being what is the best evidence of the property's value. Certainly the issues that, who are you going to get to testify, which, what appraiser you're using. Many times, and I'm sure you've seen this with several clients, they'll pick your run-of-the-mill appraisal. And that is a real issue you got to deal with because they probably don't even go out to the property. And some of them will use, Zillow or whomever to try to establish the amounts that are owed. So if you can establish all of these issues, you have the right to obtain the deficiency. I've only actually proceeded with 2 trials related to evaluation. But most of the times you'll negotiate pay out in terms of how much. But the issue that obviously I'm sure that you guys wanted to most highlight upon is what you do upon the sale. And that is a very strategic and statutory. You got, as I said, dot your I's and cross your T's as to how you're going to collect. Questions related to that part?
Yes, so if you don't mind me.
Yeah, go ahead.
So you mentioned there briefly that your witness, which is, you said your appraiser. So do you use a list or a kind of a group that you think is better for testifying, and how often do you see it contested versus uncontested?
Well, I've had 2 contested ones, and at that time, in terms of a list of who we use, I picked up the yellow pages. I'm just kidding. No, there are certain parties out there who well, it depends on the county, obviously. Okay, that's probably the most important thing. And where are you dealing with? And you want somebody local who most real estate agents up there will probably direct you as somebody who can appraise the property. And I would certainly not recommend. I've had to do this in bankruptcy court as well. Don't get somebody from Atlanta to go to Gainesville. That is not the best idea. So your consideration is obviously who is local, and use Google and find somebody who has done this. A testifying expert. I mean, I'm sure you get peppered with these via email all the time. And I'm your expert. I'm on LinkedIn, but I would probably, maybe in Atlanta, I would use somebody like that, but certainly not outside of the city. In terms of what they then need to produce, you obviously have your client come to authenticate your documents. And then you've got your expert in terms of how much the property sold for and whether it was fair,
override the sale, does that person also need to testify?
Yes. Although I did not have to do it at that time because that was not dispute, but you certainly were there as a witness because a lot of times you're the one, you know, the associates down there crying the sale. I was there as a witness in order to do it, but that generally is not an issue in terms of whether it's actually read verbatim and the sale was read verbatim. The issue is more of the valuation. Hopefully, if it's contested, you're going to have an attorney on the other side, and hopefully that's probably not something that you need to. Most of the time, you have an attorney on the side. They won't cross-examine the young associate in terms of whether they actually read the whole legal description off verbatim and word by word.
How far out do you set your Rule 9 size for these when you would start to try to file them?
I think it was about 6 months out, and it was to give you enough time to serve them and get your witness ready. And you know, it depends on your considerations. The judge will give you as much time as you generally need. So clients obviously want to get it taken care of as soon as possible. Of course, you're in front of the judge, and he asked you right there. He said, "When do you want your hearing?" And so, I mean, that's a very real issue that you probably should discuss prior to you going down to the courthouse. Determine that and talk to your client about it. In terms of when should we get the hearing placed, or to give us enough time to do this.
I don't know if you were here earlier. We had Judge Bloom from Gwinnett talking about garnishments and essentially overlap of funds from like a third party paying into a garnishment versus the asset that owed by the original offeror in the judgment. You said you had 2 surpluses come up recently.
Yeah.
How are you handling if it's already under power and owned by the institution? How do you handle that surplus of funds?
Well, the money's still in our trust account right now, so I'm trying to figure that out.
So this will be exploratory.
That'll be phase 2 of this seminar.
I mean, would you file an interpleader action?
Probably most likely.
The court and then serve all interested parties. I mean, I've seen that done with real property excess proceeds.
I would suppose so. Depends upon what your security agreement provides and whether there's another secured party. But yes, that would probably be the best action in the court. Or have I guess it would be held in escrow by your agent as well. And anything else?
I think that's actually got us.
You made it to the end.
I think we made it to the end.
Yeah, I want to thank you for doing that.
Yeah, that was great.
All right, well, we don't have a post show wrap up today, so I'll just say on behalf of myself and Shanika, Brian, and Jenny, I want to say thank you to everybody for joining us here and online, and we appreciate the responses and you being here, virtually or otherwise, and hopefully we'll be off next year as well. Otherwise, by the way, the Creditors' Rights Forum is up and functioning again. We need folks to jump on there or attempt to make sure that it is indeed doing what it's supposed to do. We've got some announcements to make. But we need body to get in it, so it's includes what is our Creditors' Rights Forum? Does anyone?
I think it's the Creditors' Rights Forum.
.org. Right. We think it is creditorsrightsforum.org. I know this inspirational leadership you're seeing right now. This is what we've got amongst the 4 of us. You're welcome to step in and help. But thank you again. It's creditorsrightsforum.org. Thank y'all. Have a great weekend.